Morning, everybody. Welcome back. I think, Mr. Warren, you were going to get back to me about the animation.
Yes, ma'am. We're preparing a note, and I was just before we started looking at the kind of final draft of it, which has involved obviously liaising with AVR overnight just to make sure about everything. So I haven't got it for you right now, but it will be very shortly this morning. So I hope to be able to put it in so that people can look at it during the course of the day and raise any questions that they may have about it.
Thank you very much. Any other matters arisen during the adjournment? No? Lovely. In which case, I'll hand over to you, Mr. Booth.
Thank you very much, Madam. So, Mr. Froneman, I'm just going to introduce you to the inquiry first of all. Your name is Ignis Froneman.
That's correct.
And you are currently a director at Cogent Heritage, a consultancy that you set up back in 2019.
That's all correct.
And prior to that, for 9 years, you were a director at Heritage Collective, before which you were an associate director at CGMS.
Yes, that's all correct.
You have a degree in architecture and you are an associate member of the Chartered Institute for Archaeologists, and you are also a member of the Institute for Historic Building Conservation, I believe.
Yes, that's right.
And I think you say that you have some 20 years experience specializing in the historic environment, including tall building cases in London.
Yes, that's all correct.
Well, Mr. Froneman, you put in a substantial proof of evidence, and we need to be proportionate as to the extent of matters that we visit, given much of the ground has already been covered by oral evidence from Mr. Stroud and Dr. Mealy. And of course, the inspector has read your evidence, both the proof and the rebuttal, ma'am, that he has provided. In terms of the position that you adopt, it's clear from the tabular statement of common ground at CD 11.6 that you fundamentally disagree with Mr. Stroud on a number of issues. Your evidence is also not entirely consistent with that of Dr. Mealy, but it's fair to say that your judgments align far more with his, I believe, than with Mr. Stroud.
Yes, I think that's a fair summary.
In terms of keeping matters relatively brisk, we are going to stand on your written evidence, comprehensive as it is. And in terms of your position regarding the majority of heritage assets in scope, that is in particular listed buildings outside of the World Heritage Site and the two other RPGs, for example, listed structures on the Great West Road and Scion Lane, we're going to take that as read and focus instead on Kew and on Scion, and we'll touch briefly on Osterley. First of all, though, I need to deal with a correction in your document. Can we turn up, I believe it's the very final page of your proof, paragraph 7.100.
Yes, I have that. That's the
overall summary.
Yeah.
We see there that you set out your assessment side by side with the assessment presented to the council in the committee report. In terms of your assessment of harm, we can note that as regards the Nat West building, you identify in that table a low level of less than substantial harm. Now, that is at odds with what you say earlier in your proof at paragraph 5.37, where your position, we don't need to turn it up necessarily, but the reference is 5.37. You find there that there would be no harm. And also the position in that tabular statement of common ground we've already referenced, you say there, no harm. So just to confirm for the inspector, please, what is your position? Do you say no harm to the NatWest building caused by these developments, or do you say that there would be a low level of harm?
No, I say that there's no harm, and madam, the the table at 7.100 of my proof is incorrect, where it says less than substantial low for the NatWest building. That should be no harm.
Thank you. Next, I want to deal with some issues relating to Kew. And to begin with, we are really dealing with what are updates to your written evidence. First of these is as regards visibility of the proposals from Scion Lawn at Kew, and also that area just to the south of Scion Lawn just by the shelter.
Mhm.
I touched on this in opening, but we need to deal with it in your evidence. In the body of your proof, for example, at 3.104, you say that you have assumed that the proposed developments would be visible from the southwesternmost part of the Scion Lawn. That is the Scion Outlook.
Yes, that's correct, because at that time there was no visualization from that southernmost spot of the Scion Lawn, and so I took the view that I should really assume a worst case scenario rather than assume that it's not visible, and so I based my assessment that on the basis that the scheme would be visible from there. And we know now from Dr. Mealy's main proof of evidence and his Appendix 4, I think it is, there is a visualization from there, and we can
Can you
see.
just go a little more slowly? And might you speak up a little more, because I can hear you just about, but I'm not sure everyone in the room will.
Sure. We can see, well, since the submission of proofs, Dr. Mealy at his Appendix 4 included an AVR from that extremity of the Scion Lawn, and we can see from that the proposed development won't be visible from the Scion Lawn.
Pausing there, that's the Scion Lawn. We also note that in your proof at 3.112, you reference the MSE viewpoint 1, and that is to say the view of the proposed development, or alleged view rather, of the proposed development from the immediate vicinity of that shelter. And I don't ask you to turn up viewpoint 1. And again, we can see there that you assume that there would be visibility from that location. And you say that that would give rise to a degree of harm. It would be very slight indeed, nearly altogether negligible, but you know that there would be harm. Again, what's your position now, having considered the evidence of Dr. Mealy, and in particular, I think it's Appendix 2 to his rebuttal evidence, which addresses that point? Do you still consider that the position is that the proposed development would be visible from that location, or not?
No, I don't think it would be visible. And I think what Dr. Mealy's rebuttal shows quite clearly is that what Mr. Spence showed as quite an extent of visibility of the appeal schemes or the proposed development in that view 1. The AVR view shows that it won't be visible. And even if it were visible, it would only be very, very marginal. And so I don't see that there would be an effect on the OUV of the World Heritage Site, even if there were such very, very limited visibility from really a glimpsed view here or there.
Well, thank you. That really takes us on to the second update, which is consequent on the first. In light of your position, your revised position regarding the visibility of the proposed development, I was going to ask you, what consequence does that have for your assessment of harm? And in light of the fact that both in the table at 7.100 of your proof and in the tabular statement of common ground, in light of the fact that in those locations you identify some degree of harm to Q, that is to say the World Heritage Site, what do you now say as to whether or not there would be any degree of harm caused to the World Heritage Site at all?
I agree with Dr. Mealy that there won't be any harm to the outstanding universal value of RBGQ.
In that context, I suppose we also have to consider not only the World Heritage Site, but also the RPG and the conservation area at Q. Does your conclusion in respect to the World Heritage Site lean into the position as regards the RPG or not?
Yes, because the boundary of the Register Park and Garden overlaps that of the World Heritage Site, and so it doesn't include the towpath. And so my conclusions in relation to the Register Park and Garden would be the same as for the World Heritage Site.
Yes, so in terms of amending your proof, both at 7.100 and the tabular statement of common ground, what do you say? Is there harm to the RPG or not?
No harm to the Register Park and Garden at Kew.
But in order to be comprehensive, we need to touch on the conservation area as well. The conservation area, I believe, does embrace also the Thames Path, doesn't it?
The conservation area includes the towpath, and we know that there would be some limited views out from the towpath, and so I would stay with a very low level of less than substantial harm because of that.
So the position as stated in your proof and also in the tabular statement of common ground as regards the CA, that remains the same.
Yes, that's correct.
Thank you. Okay. Well, staying with the Thames Path.
Sorry, before you go on, can I just be clear that I'd already got the NatWest change of position, but you're saying that also now the World Heritage Site, you're
That's
saying
correct,
no
ma'am.
harm. Okay.
So, Mum, yes,
The
that's
World Heritage Site and the RPG, no harm.
That's correct, but not with the conservation area, because the conservation area takes in the
Yeah.
towpath. So
And the NatWest.
I say towpath is the Thames path.
Okay, thank you.
Thank you, Madam. I was moving then to focus on the Thames Path. That is obviously ground that Mr. Warren has covered with Dr. Mealy, and we've both covered it with Mr. Stroud. But it is of such significance that I want to speak to you about it in oral evidence also. As I say, Mr. Stroud speaks time and again about impacts on the views from the Thames Path. I want to explore the relevance of those views to the OUV of Kew. And again, I think we might be able to take this relatively swiftly. First point, does the path lie within the World Heritage Site?
No, it doesn't. It lies outside the boundary.
Secondly, can we turn, please, to paragraph 6.18 of Mr. Stroud's document?
I have that.
You'll see that in the third sentence of that paragraph, and it's a reference I took Mr. Stroud to, he there states, the statement of outstanding universal value notes that the boundaries of the World Heritage Site contain all the sources of the attributes composing RBGQ's OUV. I put that to Mr. Stroud, and he stood by that proposition. I mean, do you agree with that proposition, namely that the statement of OUV notes that all the sources lie within the boundaries of the World Heritage Site?
Yes, I do agree with that. The only observation I would add to that is that, unlike some World Heritage sites, and I can think of the one in Greenwich or Westminster, or other ones I've dealt with, Kew is quite different because of its inward-looking nature. And I know, consultants like me often use the word inward-looking in relation to areas, but I think it's really true in relation to Kew for the most part, in terms of the gardens, in terms of the area that's encompassed in the World Heritage Site. There are, of course, the exceptions, notably including Scion Lawn. But if you look at the relationship between the World Heritage Site and the towpath, I think that relationship is more one of enclosure and separation than it is of connection. And so I totally agree that, with this particular World Heritage Site, its OUVs it is all contained within the boundary. In that sense, yes.
Thank you. Well, we have a management plan, which you've referenced, which was adopted relatively recently in 2020. In terms of that document, we've already agreed that the plan had input from Historic England. And in terms of the focus on the Thames Path in the management plan, we have seen that there are some references to it in the document. We've already looked at those with other witnesses. Just please, your confirmation in terms of the references to the Thames Path. What, if any, references are there to the importance of views available from the Thames Path looking away from the World Heritage Site and across the Thames towards the proposed development site?
None at all. Insofar as the Thames Path is referenced, it is almost in all cases referenced in relation to the fact that the World Heritage Site is separated from it rather than integrated with it. There are no references whatsoever, and this is it's a big document. The management plan. It's got specific emphasis on setting. It's got a whole appendix on setting, and there's nothing in there to suggest that views from the Thames Path are in any way relevant specifically to the outstanding universal value of the World Heritage Site. And I think reading through the document, I can't see any reason why that would have been excluded for any reason. I think if that was considered to be relevant or important for any reason, it would have been mentioned. There's no such mention.
Thank you. I'm going to come back to that point in a moment, but before we look at it, I mean, you've mentioned the management plan. I think you described it as a big document. I mean, do you regard it as significant in the context of this inquiry and the position advanced by Historic England? I mean, is it a document to which the inspector should pay material regard, or is it in some way peripheral to the analysis?
It's highly relevant, and it's highly relevant because policy directs us to consider it, and that's in the London Plan. It specifically says that an up-to-date World Heritage Site Management Plan it should be taken into account in development management decisions. And so here we have an up-to-date World Heritage Site Management Plan. Policy tells us to take it into account. It's highly material. And what it says is, what it doesn't say is that the towpath is of any importance or even relevance really to the OUV of the World Heritage Site.
Well, a moment ago, you gave your position, gave your view as to the fact that there not being a single reference to significance of views from the towpath contributing towards OUV. That is to say, views from the towpath looking away from the World Heritage Site. When that was put to Mr. Stroud, I think both by myself and Mr. Warren, his position was that there weren't any explicit references, but there were plenty of implicit references. That is to say, I don't know, if you read between the lines, it's clear in his view that the Thames Path makes just such a contribution to OUV as he suggests. What do you say as to Mr. Stroud's reliance on implicit references, and do you accept that there are such implicit references?
Well, no, I don't see any implicit references being made in the World Heritage Site Management Plan. I mean, you know, there must be something that implies that the towpath is important, or views outwards from the towpath is important. There's nothing that implies that. But I would make the further point that I can't see any reason why in this quite comprehensive document that looks in quite some detail at the setting of the World Heritage Site, why the authors would feel that they should only imply something if it is highly relevant. I don't understand why they would tiptoe around the issue. You know, they're perfectly clear about what they say on all other matters of setting. I don't understand why this should be one that they felt that they couldn't address in plain and simple terms and using plain English language. So I don't see that implicit reference. I don't understand why it is that there would be such a reference and why it wouldn't just be plainly stated.
Thank you very much. The third point that I want to touch on in the context of Kew, I mean, it relates to Kew, but in fact, it has a wider application to other heritage assets, in particular Sion, but we'll address it here. And that is scale and judgment of harm. As regards the World Heritage Site, the inquiry is aware that Mr. Stroud is alleging middle of the spectrum of less than substantial harm. Now, we know that in reaching that view, he's been informed by impact on the Thames Path lying outside the WHS And he says that without those views, he would only put his case at there being a low level of harm at Q. But the point I want to look at is really a bigger contextual point. When considering impact on the OUV of the World Heritage Site, I asked Mr. Stroud, do we consider only impacts on views or setting of the World Heritage Site where the proposed development will be visible? Or do we consider the setting of the World Heritage Site and indeed the heritage significance of the World Heritage Site as a whole in the round? Now, he confirmed that the correct approach is to look at the overall heritage significance of the asset. And I need to have your view, please, on that point. Do you agree with Mr. Stroud that one looks at the position in the round and in totality, or not?
Yes, I agree with that. You have to measure any impact against the totality of the significance of the heritage asset, and that significance is made up of the physical fabric of the heritage asset. In this case, it's a designed landscape containing all those highly iconic listed buildings and so on. And the setting is also a contributory factor to the overall significance of the asset. So that is what you measure impacts against.
Well, the reason I raise this is because in cross-examination, of Dr. Mealy, Counsel for Historic England referred to the Tulip decision and the Citron decision that we have in the core document. You're familiar with those?
Mm-hmm.
And he raised the point, or raised rather the approach identified in those decisions, and I'm going to slightly elide the language because it's slightly different in the two cases, but it's essentially the same point. He raised the question, or raised the issue, that the key point is not whether some aspects of significance would be unaffected, but instead the key point is the impact on what would be affected. Do you recall those observations in the decision letters and the inspector's reports in Tulip and Citron?
Yes, I do recall that.
Okay.
Yes.
Well, what do you say as to whether those decisions have the effect that one should look only at the aspect of significance that is adversely affected?
Well, I think the first point to make is that in both those decisions, my reading is that the aspect that is being affected, that's referred to in those decisions, is setting. So what those decisions say is that you don't just look at physical fabric and discount setting, or look at physical fabric and say, well, that's not being affected, so setting doesn't really matter.
Actually, pausing there, yes, both those decisions are concerned with impact on setting. Do those decisions suggest you look only at that part of setting that is adversely affected?
No, those decisions specifically refer to setting. They don't talk about one part of setting. So even when you're looking specifically at how setting would be affected, you would still need to look at the whole of setting and how the whole of the setting is affected. But of course, you then have to calibrate the harm against the totality of the significance of the heritage asset. And that includes the contribution of its setting to its significance, but also the inherent significance that its fabric contains.
Well, in that context, Mr. Warren took Dr. Mealy to ID document ID 1 spot 11 spot 3. That is, it's the allotments decision, I think. That's ID 1 spot 11 spot 3, paragraph 14 of that decision. And if we just turn that up very briefly. It's Appendix 3 of Mr. Stroud's appendices.
Yes, I have that.
The allotments decision, and of course, this relates in particular to Scion. And if we look at paragraph 14, take this briefly because the inquiry has already seen it. 4 lines up from the bottom, we see the inspector noting that as such, the proposal would adversely impact on its setting. However, this impact would be relatively modest given the house's extensive setting, and in my judgment, insufficient harm to its overall significance as a listed building, which in large part relies on its Adam interiors and its historic fabric. Pausing there, I mean, first of all, what do you say as to the inspectors, departing from Q very briefly here, but what do you say as to the inspector's observations regarding the heritage significance of Sion?
Well, what the inspector did there was exactly what I just described. So first of all, you look at the impact on setting, taking into account that there may not be, that the whole of the setting may not be affected. And then you relate that back to the significance of the asset, which also includes the physical fabric and so on. So that's exactly what the inspector did there. First look at the component that's being affected, then looking at setting on the whole, and then looking at the significance of the heritage asset on the whole. So that is how you calibrate the harm.
Thank you. Well, and can we also look in this context, please, at a document that came in more recently, at ID 2.54. That's the Edith Summerskill House appeal decision.
Yes, I have that.
Yes, and we can note, can't we, that that is a decision of July of this year.
Yes, that's right.
And that's another decision by the, well, it's not, in fact, by the Secretary of State. It's by the Minister of State for Housing on behalf of the Secretary of State. And I believe you were involved in that decision.
Yes, that's correct. I gave heritage evidence of that inquiry on behalf of the applicant.
Can we turn, please, to paragraph 12.49 of the decision?
Yeah, so to that I think the inspector there references the Bedford decision, and there's been some discussion about what substantial harm means, and I think the inspector there takes into account Bedford and the PPG.
Yes, and then moving on to 12.50, please. What do you say here as to the approach adopted by the inspector, which approach we can see from the decision letter was endorsed by the Secretary of State? What do you say as to paragraph 12.50 and whether or not that approach is consistent with the approach that you have just advocated and pointed to in the context of the allotments decision?
Yes, well, I suppose the first point to make about 1250 is that there the inspector doesn't talk about the specifics of that particular development. You can read the whole of 1250 and there's not a single reference to that particular scheme. The inspector is there talking specifically about the approach. And I might just add that the reason why the inspector talked about approach there, having been at the inquiry, the opposition was Mr. Turney, and you might see, ma'am, if you look at it, that Mr. Turney was also involved in the Tulip decision. So there was some discussion about setting and how to apply the approach to setting and so on. And so that's a context, I think, in which the inspector made that general observation at 1250. And I think that's helpful because what the inspector there talks about is the approach specifically to cases where it is setting that is affected, bearing in mind that in that case, we are dealing with a highly graded building. It was grade 2 star listed. But the inspector, of course, doesn't talk about that in 1250. He just talks about what it is that you take into account when you are looking at setting effects. And he mentions there that the significance might be in many cases the significance of the heritage asset, the significance that the heritage asset derives from its setting might be limited. It's not necessarily in all cases like that, but in many cases that is the case. And where that is the case, so in such a case, unless the asset concerned derived a major proportion of its significance from its setting, then it's very difficult to see how an impact on its setting can advance a long way along the scale towards substantial harm to significance. And so I think that's just, going back to the steps. You look at the impact on setting, you look at the contribution of setting to overall significance, and then you calibrate it against that. So I think that's quite helpfully and clearly set out here.
Well, I mean, the term the term Dr. Mealy used was contextualize. He said it was important to contextualize the harm, notwithstanding a key point is, of course, that aspect of heritage significance which is adversely affected. That is the key point, but you contextualize it. What do you say as to the approach that Dr. Mealy identified yesterday and his contextualizing methodology? Would you accept that as being appropriate or not?
Yes, I think it's appropriate. I've been referring so far in evidence, and I've been referring in my proof of evidence, in fact, I use the word calibrate rather than contextualize, and I think calibrate is just a better description of what it is that you're doing when you're assessing levels of harm. It's one thing to identify harm, but you then have to put that in the context of, so Dr. Mealy's words, or calibrate it against my words, the significance of the heritage asset in its totality. So I think it's the same approach. We use slightly different language, but that's I think we're on the same page.
Thank you. Next, in terms of Q, so returning from the generality to the specific, I just want to touch briefly on the ICOMOS document that was put in the course of the inquiry. That's ID 234, 2-34. We don't need to deal with this at length. Dr. Mealy dealt with it yesterday, but there were just a couple of points. I mean, firstly, you'll recall that when Mr. Stroud was cross-examined by Mr. Warren on this document, Mr. Warren raised with Mr. Stroud the issue of whether or not the author of the document had undertaken a site view, and Mr. Stroud was slightly coy and said, well, he didn't know because there wasn't a reference one way or the other in the document. Just so we're clear, your position, please, as to whether or not there has been a site view undertaken by the author of the report. Is there anything in this document which suggests that such a site view was undertaken?
No, and I think, in fact, what the document suggests is that a site visit wasn't undertaken. And ma'am, have you got the document in front of you? So if you turn up page 4, please. At the very bottom, you can see there that it says ICOMOS, Charenton-le-Pont, which is a suburb of Paris. That seems to me where it is, where this letter was written from. I don't know if that's the case, but if that's the case, and it seems to me highly unlikely that a site visit was made. There is no reference to a site visit having been made, although the document specifically references what it is that was being considered. And so I would have expected that if there was a site visit, that would have been identified.
Thank you. Next, in terms of the management plan, there was some discussion as regards, in the context, I think, of the cross-examination of Dr. Mealy as to whether or not the management plan was before the author of the report when they wrote it. Firstly, can we look at page 3 of the document? Halfway down, there's a heading, documentation consulted for review.
Yes.
First paragraph, state party submitted a heritage statement, ... volume 2, 2 letters from Historic England. Any reference to the management plan there?
No, there's no reference to the management plan there.
Next paragraph, application for permission for these developments submitted to the LPA has been called in. Voluminous documentation from the developer objectors and the LPA are in the public domain and available online. Again, anything there to suggest that the author of the report has found the management plan and has read the management plan specifically?
No, and as my recollection is that the management plan wasn't published online as part of the application documents.
Lastly, in that context, can we go please to the final page of the document, and the penultimate paragraph beginning "the property has." Do you see that? It's page 6. It's not numbered, madam. It's the paragraph beginning "the property has a World Heritage Site Management Plan." Do you have that paragraph?
I do, yes, yeah.
That reads the property has a World Heritage Site Management Plan, Property Conservation Plan, and a Master Plan. Implementation of the management plan is coordinated by the RBGQ. The World Heritage Site Management Plan is currently being revised. Just so I'm clear, is it your understanding that the WHS management plan is currently being revised?
No, ma'am. If you turn up the management plan, I don't know whether you've got quick access to that.
That's core document 10.1.
That's it, CD 10.1. Cover page, of course, ma'am, you'll see 2020 to 2025. So it's been around for a while, and if you go to I think there is a specific reference to the document when it would be updated again, and I think that is at the end of its term in 2025.
Well, in that context, can we look, please, at the executive summary, page 5 of the document? Do you have that?
Yes, I am just getting there. Yes.
And there are 2 columns on page 5. The second column is entitled Preparation and Implementation of the Plan.
Mm-hmm. Yep.
Final sentence in that column, please. How does that read?
The World Heritage Site Management Plan will be reviewed again in 2025, and evaluation of the plan success and any changes will inform the development of the next one. So, in other words,
what do all those matters suggest to you as regards the familiarity of the author of this report with the actual management plan, as opposed to some earlier iteration of the document, whilst this plan was in preparation?
Well, it seems to me quite clear that the author wouldn't have had access to the adopted management plan because they thought that the management plan was being reviewed. So they might have looked at something earlier, an earlier draft, I don't know. But certainly there's no reference to this adopted one, which is the current one.
Okay. In summary on Q, I mean, we know what your position is, and you've set it out in your proof, and you have updated that position, having regard to the evidence before the inquiry. You're obviously in fundamental disagreement with Mr. Stroud as regards impact on the World Heritage Site and the RPG. Can you briefly, please, for the inquiry, summarise how and why it is that you consider Mr. Stroud has got matters so wrong?
Well, I think in brief, if you look at the level of harm that Mr. Stroud puts the development as causing to the outstanding universal value of the World Heritage Site, to arrive at a mid-level of less than substantial, and bearing in mind what I just read about the Edith Summerskill decision and the extent to which a heritage asset may or may not draw significance from its setting, and combining that with the degree of effect that they would be even taking into account the views from the towpath, it's very, very difficult for me to see how reasonably you could put that harm in the middle of the spectrum of less than substantial if you have regard to what the NPPG and Bedford says about what substantial harm means. And bearing in mind, I suppose, just the scale and the complexity and the richness of heritage significance that the World Heritage Site has, bearing in mind the extent of its setting, it's very, very difficult for me to see how reasonably any harm could be at that level that Mr. Stroud puts it.
Thank you very much. Okay, I just want to touch before we leave Kew altogether on the Isleworth Ferry Gate. That's the only one of the 56 listed structures at Kew where Mr. Stroud alleges a direct impact. He talks about the Ferry Gate at, I think, well, for the inspector's note, I've got references at 6 spot 48, spot 61, and spot 70 of his document. And he asserts that there would be a medium-high level of less than substantial harm. You deal with this at 7 spot 36 and following. To be clear, I don't understand you to dispute that there would be intervisibility as regards the gate and the proposed development. Is that right?
Yes, that's right. But I also make the point, and it may be worth just actually, it may be worth just turning it up. I've got
This
a
is
photo.
your proof at 7.36.
It's actually, I wanted to take the inspector to something else, which I think sort of illustrates it, and that is, if you turn up my proof at page 79, and I'm looking specifically at photo 22. Uh, 79, yes. My main proof, 79,
Yes, then
photo
that's the
22.
right reference. Yeah.
And so there, ma'am, you see the ferry gate and you see a view of it, and you see hanging over it the branches of a yew tree. The photo was taken in January this year. So obviously, deciduous trees, which you can see on the left, were leafless, but the evergreen sort of overhangs the ferry gate. And I suppose the simple point to make really is that if the ferry gate drew such significance from what you could see beyond it, then that tree there must cause a mid-level of less than substantial harm because it prevents that view from being seen. And I just don't see it. I can't see how that's a reasonable proposition to take. I don't know whether Mr. Stroud saw the tree. He doesn't mention it. He doesn't mention interference with that view that he considers to be so important that it contributes so much to the significance of the ferry gate. I don't understand how it is that he finds such harm.
Thank you. I want then to move away from Kew and turn to Sion, House and Park. We've already touched very briefly on Sion and its heritage significance when we were considering the allotments appeal decision. But again, very briefly, please, summarise for the inspector what you consider to be the heritage significance of Sion House. Where is it to be found? What is it?
Well, in very brief summary, I think I can agree with the inspector about the allotments decision, where the inspector found that a lot of the significance of Sion House is embodied in the fabric of the building, and specifically the Adam interiors are mentioned. And I think Mr. Stroud agreed to that in cross-examination. I certainly think that that's true. Pevsner is somewhat disparaging about the exterior of the building. I'd say in my proof that I don't entirely agree. You know, I wouldn't put it in such disparaging terms, but I think there's a distinction between the interior and the exterior of the building, and I think more interest lies inside than outside, if you like. Despite that, the exterior of the house, I don't want to talk it down or to sort of downgrade it, but I think that there's more significance in the interior than the exterior, and there's then the sort of group value and setting value that the house has with a designed landscape it sits within, and the pepper pot lodges, but also the listed structure that's now the garden centre. So that's sort of a summary, I suppose, of the setting's contribution to the significance of the house. But in summary, I think most of it lies within the fabric of the building.
Well, you say most of it lies within the fabric of the building, and that's evidently the view of the inspector at the allotments decision. At 4.74 of your proof, you touch on what Pevsner had to say about it, and you've just alluded to that a moment ago. We know that Mr. Stroud has not engaged with Pevsner's view Pevner's opinion, rather, as to the exterior of Sion, and he explained to the inquiry that he hadn't referenced that because he disagrees with it. Just first of all, can we turn, please, core document 11.2, which is the heritage statement of common ground?
Yes, I have that.
Paragraph 4.3 of core document 11.2.
Yes, I have that. I do remember that because I was party to this agreement.
Yes. The parties agree that the historical and architectural significance of the relevant heritage assets can be understood with the aid of the following documents, albeit not an exhaustive or exclusive list. And we've then got 6 bullet points, haven't we?
Yes, we do. And the last of those bullet points is, of course, Bevsner, the buildings of England, London 3, Northwest.
Right.
And the extracts are then sort of appended or at the end of the document.
So that's a reference to Pevsner. What do you say as to the approach adopted by Mr. Stroud, which is to say that in his proof of evidence, he doesn't reference that because he doesn't, I think the way he put it was, I don't entirely agree with it. Because he doesn't entirely agree with it, he hasn't put that in, he hasn't engaged with it. What do you say as to whether or not that is an appropriate approach in terms of providing analysis to the inquiry?
Well, I don't think Mr. Stroud is bound to Pevsner's view of Sion House, but I think if you agree in a statement of common ground that it is something that aids with the understanding that the heritage assets can be understood, Sion House can be understood with the aid of the following documents, and bearing in mind that I think nobody has really gone into the detail in relation to Sion House that Pevsner has. There's a long entry, and the Pevsner is based on very good research. It's highly respected, and so I think if you do disagree with it, then I think it's only fair really to state it. But not only that, if you agree in a statement of common ground that's something that you look to assist you in understanding the significance of the building, and you then disagree with it and you don't say anything about it, I think it's not something I would do, and I as a professional witness, I have some issues with that.
Thank you. Turning away from the house then and to the park, as regards the significance of the landscape of the park in heritage terms, I want to consider firstly the views outwards from the park towards the Thames and Kew. That is to say, looking back towards the Sion outlook at Kew. Are those views from Sion significant or not?
Yes, and I think that so far there's been nothing really said about that, and I think, it is worth drawing your attention to that. And I think if you have it, I would direct you to page 104 of my proof of evidence. And on that page, I think that there is another view, but let's use that one for the time being. Actually, just for your reference, the other view is on page 112, but let's stay with 104. You can jot down 112 if you like. What you see at the top there is a sort of aerial view of it, and you can see in that top aerial view, sort of around the middle, sort of say the top third of the page, you can sort of see the ha-ha, and it's slightly curved. And of course, we know what the ha-ha was meant to do. The ha-ha was a device to visually integrate landscape. So in other words, where there's a ha-ha, you know that it was intended that views would have been outward from in front of the ha-ha, if you like. And you see that view there at page 30, at photo 34, the bottom, and that's the view from the sort of loggia, if you like, or there's sort of the back of Sion House facing the river. And you can see there that you look towards the World Heritage Site at Kew, and it's a view that's where there's no development present, and so that's also part of Capability Brown's designed landscape at Sion. It's the earlier part of Capabilities Brown landscape. The western part came later, but I don't think that's so important. But the point being that it's a landscape in two parts, and the eastern part, of course, doesn't have the intrusions that you see in the western part. And so when we think about the landscape, I think it's just important not to just think about the western part of it. There's also the eastern part, and those views outwards from the eastern part are highly significant, I think, because it also connects the two Brownian landscapes, although Kew came later. But I think it's just relevant not to lose sight of that.
Well, in that context, of course, there's been much talk, particularly by Mr. Stroud, of Arcadian landscapes and rural illusions and so on and so forth. In looking at photograph 34, to what extent is the Arcadian landscape preserved, and to what extent would the proposed development interfere with it?
I would say that there's a high level of preservation along the east. In fact, the intrusions that I found there was the pagoda at Kew in some places when you look in some directions, but that's really about the only sort of modern intrusion that you see in that eastern part of the landscape. And so I think that if there is such a thing as an Arcadian illusion, bearing in mind that you've got, so you've still got the aircraft flying overhead and so on, you're still aware that you're in London and so on. But if there is a place where you have that Arcadian illusion, then it's that eastern part of the landscape, which you don't get on the west, because you're much more aware of development beyond the park.
Well, staying with this issue of the Arcadian illusion, and the otherworldliness that's being suggested, I'll pick up the point you've just raised now. Mr. Stroud agreed, I believe, when we discussed matters, that he made no attempt in his report to engage with the issue of aircraft noise at Sion and the awareness one has of planes passing overhead. What do you say as to whether or not that is relevant as an issue in the context of his assertion as regards the outside world being excluded? What do you make of his omission? Is it a relevant factor or not?
Yes, it is relevant, and we don't have to turn it up now, but you'll remember, ma'am, the checklist in GPA 3, the historical and setting guidance, and that included things like noise and movement. Of course, the aircrafts introduced quite a bit of noise and movement. I mean, I remember when we were on the site visit, we had to raise our voices at one point or stop talking because of the aircraft overhead. And it's not the be all and end all of it, but it's certainly relevant. It's certainly, to ignore that or not to take that into account, it seems to me is an omission, and something that is materially relevant.
Okay, well, as regards the intrusion of other elements of modern life into Sion Park, I just want to talk about a number of heritage assets within the park, which we discussed with Mr. Stroud when he gave his own evidence. Firstly, can you turn up paragraph, or rather page 111 of your proof, please?
Oh, yes, I have that. That's two photographs.
Yes, we've got there two photographs, the lower of which deals with the ornamental bridge, and the one at the top of the page, photograph 37, is looking down the Great Lime Avenue, I believe, from a location close to the Pepper Pot Lodges. I'm taking the Pepper Pot Lodges first. Mr. Stroud says that there is a medium level, I believe, of less than substantial harm, and he makes reference to the presence of the proposed development in oblique views as regards the Pepper Pot Lodges. He didn't make any reference to the modern development at the end of the Great Lime Avenue. Your view, please, as to whether or not, in terms of intrusions into the park at Sion, that is to say the Arcadian illusion and also the setting of the Pepperpot Lodges. Is this relevant that we see modern development at the end of the Great Lime Avenue or not?
Yes, it is. And I think what I didn't say with my previous answer when you asked me about aeroplanes, and I think this is relevant, it's equally relevant to what these photos show, is ma'am, and again, we don't need to turn it up, but you'll be aware that the definition of setting in Annex 2 of the NPPF is the surroundings in which a heritage asset is experienced. And the point being that these things form part of the experience. So you don't experience the bridge as detached from modern development beyond the park. Not that I think it's a major feature in a sort of landscape sense. This view of the bridge along the Lime Avenue is probably perhaps the best view of it, because you see the sort of structure, you see the arch, and you see it at the end of this significant avenue, which is obviously meant to draw the eye, and you experience the bridge there in the context of a sort of hinterland of modern development. And so the best views in which to experience the bridge, part of that experience is the context of modern development beyond the park. And so you're not unaware that there is a designed landscape within which the bridge sits, but then beyond that there is a sort of modern hinterland. And I think that's relevant to how the bridge as a building is experienced. And it is then relevant to how it may be experienced with a proposed development in place. But I would just say that I think that these are probably the best views of the bridge, certainly from this part of the park looking in that direction.
Okay, well, you've moved on to talk about the bridge from the Pepperpot Lodges. If we're talking about the bridge, I'd also like you to look at photograph 27 on your page 96.
Oh yes, I mean that's a closer view. That's obviously, ma'am, you crossed it, and you know that's a view where you can start to see the ironwork and the arch and sort of the way in which the bridge crosses the lake, which obviously is what it relates to most intimately in terms of its design and function. It also relates quite intimately to the two bits that you find on the other side of the lake, the one being the sinuous drive and the other one being the Lime Avenue. But what you see there again is you see various modern buildings in the context of this sort of close experience of the bridge. I mean, my own experience there was that when you look at the bridge at close quarters, the rest of what you see in the background sort of fades away, really, because you can't really look at the bridge and the hinterland at the same time. Your eyes just can't do it. And so really what you see when you're in close proximity to the bridge is the bridge and the avenue and the water and so on. But to the extent that you do experience something beyond it or something beyond the park, it's quite clear again that you see the bridge and you experience the bridge in the context of modern development beyond the park.
Well, as I say, I want to sort of rattle on and not dwell too long on any particular aspect. We've touched on the Pepperpot Lodges, we've touched on the bridge. I also want to touch on the Line Gate and the adverse impact alleged as regards its heritage significance. I mean, Mr. Stroud has talked about it as an eye catcher, and he's pointed to MSE Viewpoint 7. As regards the role which the Lion Gate was intended to fulfill and the extent to which it was supposed to be seen from within the park, I think you really addressed that in your proof. So I'm not going to ask you to repeat that evidence, but I am going to ask you to touch briefly, and again, it comes back to our rural idyll or our Arcadian illusion in relation to this part of Syon Park. It's the question of the road that sits behind the Lion Gate, and the fact of there being a bus stop with double-decker buses pulling up outside. Again, that's a matter which Mr. Stroud and I agreed he hadn't addressed in his report. Your view, please, as to whether that is relevant in a context where we are considering Arcadian illusion in the context of Syon Park, please.
Well, there's no Arcadian illusion, and you're very much aware, I think, of the presence of the buses and the traffic, and not just that, but also the adjoining sort of suburban development that you see behind and through the gate, and not just that, you also see the Sky Campus when you close there, and you see the Sky Campus right through the sort of central arch of the gate when you're getting, especially when you're getting closer to it, and so I don't see that as sort of being a real sort of Arcadian illusion. I would just draw the inspector's attention to two things in my proof. They're both historic drawings. I think the first one is the drawing by Robert Abbon, which you'll find, Madam, on page 99 of my proof. And you can kind of see, sorry, I'll let you get there first. And you can kind of see there what the design intent of the Lion Gate was. But I think what's for me quite telling is that what you see in the background of the Lion Gate is you see lots of trees, and I think that to me shows that whereas it would have been quite visible from the street or from the road frontage, I think there was less emphasis on it being sort of visible from within the park. But I think, ma'am, if you then turn up page 129 of my proof, and I think I include this image twice, but that one will do. That's the engraving of 1800, and again there I think what you see is how the gate related to the road, and obviously it was much more rural at that time. But I think what's telling is again the trees that you see behind the Lion Gate at that time, and I think that sort of tells you something about what it was, what it was that you saw in front of the gate, and how the gate related to the road, and how the gate related to the park, which it seems to me those trees must have obscured it to a large extent when viewed from within.
Does Mr. Stroud engage with the presence of trees as depicted in that image within the park, and the extent to which they would interfere with views of the gate as one passed up the sinuous drive towards it?
No, I didn't see him do that at all. And I specifically looked at how the bridge would be experienced if you exited. How the bridge would be experienced if you exited the park through the Lime Avenue, and then across the Wyatt Bridge, and then along the sinuous drive, and then out the bridge.
Out the gate, I think you would mean.
Sorry, the gate, yes, and what that shows, and we walked it when we were on the side, is that you don't actually see the gate until you're sort of fairly close to it. But what you do see on approach of it is, again, you see the buildings along the Great Western Road, and so you're very much, again, I think it just goes to the experience. You're very much aware of those larger buildings that you see in the hinterland of the park, and by definition in the hinterland of the gate.
Thank you, Mr. Freedman. Lastly, in terms of Scion, I want please to turn to Mr. Stroud's paragraph 6, spot 114. If you could turn that up.
Bear with me. Which page is that?
That's page 151 of Mr. Stroud's document in terms of the internal page numbering.
Yes, I have that.
Well, I want to look at that reference because you'll recall that I spoke to Mr. Stroud about his use of language and use of the term shatter. And his response was, well, he only ever used that term in respect of a particular view. It didn't have a broader application. I just want to look at what's said here, and then I want to understand the extent to which you do or do not accept it. 6114, the proposed developments would do harm in views in many parts of the park, affecting the significance derived from several layers of its landscape, and in views contributing to the settings of the important listed buildings within it, not least the house itself, specifically by its complex visual interference with roofline and profile of the house, dominance over it in the Kew Riverside views. The proposals would cause medium high in the range of less than substantial to the house, cumulatively with the impact from the Western Parkland described below. Their visual distraction and shattering of character would also harm the RPG. What do you say as to whether or not that is a fair understanding and reflection of the impact of the proposed development, looking as we have done at the extent to which modern development already impinges in the western element of Syon Park. Shattering of character. Would you accept that or not?
No, I think that's grossly overstated. I can't see how that could be a reasonable proposition. You are obviously aware of different layers of a townscape beyond the park. Some of it you see close by, and sort of behind it through the tree canopies or just above them, and some of it are the larger, further away buildings, which you see in various places. There's, of course, also the hotel that sits within the registered park. And I think in that context, where you're very much aware of surrounding modern development, to sort of say that it would shatter the character of the park, I mean, I don't understand. I mean, unless Mr. Stroud is there measuring the character of the park as some idealized version of it that excludes all the things that have happened in the history up to now in the 21st century. But measured against the existing baseline, the only way in which I can describe that is very much exaggerated, to the point of being it beggars belief, really.
I want to turn finally and very briefly, given the time, to Osterley. Here, there is no dispute regarding any impact on the significance of the house. We have no alleged impact on its setting or heritage significance. In terms of the park, can you very briefly characterize that for us? Are we looking at another Kew, that is to say, another otherworldly experience? Do we have a rural setting?
No, not at all. And I think that there's two sort of two very clearly legible components of the sort of townscape context of Osterley. And the first is the sort of interwar housing that you see quite close to the edges of the park. If you look at the historic maps, we don't need to turn those up, but it's a matter of fact and record that historically the park would have been set in a sort of a rural landscape, and you can see that there were some farms dotted around it, but and maybe some market gardens, but it was essentially a sort of a countryside location, if you like. And then came the sort of the late 19th century and then early 20th century development, which really changed the setting of the park in quite a visible way. And so you can very clearly see when you're walking around the southern park and the eastern parts of the park, you can very clearly see these houses and the development sort of on the edge of the park, and they're quite prominent. Some of it is sometimes obscured by intervening planting, but especially around the south, it's a sort of very clear, harsh edge, and you can see in various places, various points. And I'm not just talking about the eastern part of the park. I'm talking about the southern part of the park, the eastern part of the park, the western part of the park. You can see variously larger scale developments dotted around and visible in many places from Osterley Park. Of course, you've got the M4 cutting through it. And so there's no real sense or illusion of the park being in a rural setting, or that it's separated or somehow uninfluenced by the modern development that you can see. You can see Wembley Park in some places. And of course, if you stand right in the heart of the park, in front of the house, you can see the tall buildings that you in the distance, in those sort of important views across the lake. So you very much, even in the heart of the park, you are aware that you're in London, and that there's a very modern hinterland beyond the park. So there's no illusion, there's no sense of sort of absence of development, or that the park is enclosed and that there's nothing beyond the boundaries.
Thank you. Then the only specific point I wanted to take up with you was as regards the setting of the lodges. That's the white green lodges. I raise this because Mr. Stroud, I think, has taken issue with your suggestion that the lodges were not intended to be seen from the rear. That is to say, that wasn't an important view of them. What do you say is the relevance of views of the lodges from within the park? I mean, obviously you take the inspector where you wish to. I'm looking for myself at your figures 10 and 11 on page 46 of your proof. but can you please tell the inspector what you say is the position as regards the views of those lodges?
Yes, I mean, I think when you look, Madam, at figure 10, then you can see. I suppose there are two sort of headline points there. You can see the landscaping, the sort of peripheral landscaping around the park. You can see that just to the top and the bottom of Wick Green Lane and the lodges. Then the second thing that's immediately apparent, and especially that's why I had the two maps there next to each other, is you can see how the lodges became enlarged by 1896. So they were initially quite very small structures, and then behind them there was peripheral planting. Now, of course, we don't have maps going back to the 1770s or the 18th century before the OAS maps, but I think what the OAS map shows is that there seems to be what I would describe as mature trees behind those lodges. And given how small the lodges were, and if you look at what's depicted there on the 1865 OAS maps, you can see in front of the lodges a clearing, and you can see almost a line with the gate, also designed by Adam, and then the lodges sort of forming a line, and then addressing that sort of entrance to the park. Whereas at the back of it, they were really sort of obscured by trees, and I haven't seen anything in the design of the lodges today that would indicate to me that they were intended to be seen, and I'm not surprised by that. I don't think that they were intended to be seen from the back, and I don't think that the extensions that have been made in the 19th century sort of really adds to the significance of those lodges, or that it helps you to understand them as sort of Adam lodges that were very small originally, and that were sort of designed to address the entrance to the park. And so the views of, yes, of course, you can see the lodges from various places within the park, but I don't think that really, it helps you to position them, but it doesn't really reveal their significance. And so I think that there's a distinction between being able to see them and being able to understand their significance. And so I don't think that views at the back of the lodges particularly contribute towards their significance.
Thank you very much. Mr. Froneman, I'm sorry, Madam, we've run over slightly, but I think we're going to leave it there. Thank you.
I am.
Thank you, sir. Good morning, Mr. Froneman.
Good morning.
As I have done with Dr. Mealy, I'm not going to go through every point or even every asset with you. I just want to ask a few questions on approach. Then look at Austerley Park, because I didn't cover that with Dr. Mealy, and then a couple of miscellaneous points on Kew and Sion. Now, as far as approach is concerned, just so we can confirm your position, you were asked about the tulip decision, and perhaps we can just take that out, please, at CD 9.8, and can we go to the decision letter, which in the PDF version is on page 4.
Bear with me. Yes, I have that. Which paragraph?
Paragraph 16.
And if you can give me a page number, that'll speed things up.
It's internal page 3, PDF page 4.
Paragraph 16 of the secretary.
Yes.
Yes, I have that.
And in short, the Secretary of State concluded the key point is not whether some aspects would be left untouched, but the importance of what would be affected. That is the setting to its significance. And there's agreement with the inspector's approach taken at 14.2. I mean, just to confirm, you don't dispute that approach as a matter of principle, do you, Mr. Froneman?
No, I don't. I'll just highlight, as I did in chief, that the inspector's not there referring to some part of setting. He's talking about the setting as a whole. to the significance. So,
Right.
there's a distinction between just looking at the part of the setting that's being affected and looking at the setting on the whole.
Right.
So of course, just to go a step further, then, if only part of the setting is affected, then of course you have to calibrate that first against, how much of the setting is being affected, and then the degree to which the setting contributes to the whole of the heritage asset significance.
Right, but but I understand the point you're making, but we agree with that. And just to round off the point, if we go on to the inspector's conclusion at 14.2, which is on page 151 of the PDF.
Yes, I have that. Is it worth me just reading that?
By all means, do. At the end of the paragraph is the relevant. Where the inspector says, as at Citron, the key point is not whether some aspects be left untouched, but the importance of what would be affected. That is the setting to its significance.
Yes, I could agree with that. And I think, in a way, that's all stating the approach that's normally taken. So if you look, for example, at the way in which my proof is structured, very much the focus is on where the impacts would occur. I think the same goes for Dr. Mealy, and I think the same goes for Mr. Stroud. So I think we, there are places I think where I refer to those things which are not affected, but I think that's in the context of calibrating the harm, because it is necessary to calibrate the harm. But it's not. I don't think any of the three witnesses, heritage witnesses here, have sort of majored or focused on those parts which are not being affected, unless, of course, that tells you about where the significance of the asset lies, because that is important.
Yes, because what the inspector there is basically saying, when you're looking at impacts, you don't focus on what was left untouched. Look at the importance of what is affected. And again, you don't disagree with that, do you?
I don't disagree with that, but I would go a step further and say that I don't think any of the witnesses of this inquiry has done that.
Okay. Now, you also mentioned the summer skill decision. I just want to see the context for that. First of all, I mean, if we go to the Citron decision, which is CD 9.1.
I have that. Which page are we on?
We're going to the inspector's report, paragraph 1515.
If you can help me again with the page number, that'd be really useful.
It is, bear with me while my computer catches up. Yes, it's internal page 105, PDF 127.
PDF 127. Bear with me. So which paragraph? Sorry,
1515.
1515. Let me just take a moment to read it, if you will. Yes, I've read that.
Thank you. And again, where this started was the conclusion of the same inspector in the Citron case. So the applicant felt it must be relevant that the scheme would affect part of what makes the WHS significant, but leave other aspects of significance untouched. However, the key point is how important that aspect would be affected. That is the setting to its significance. That's a start. But if one, just to trace this issue has taken place, if one looks to the bottom of that paragraph, you see various paragraph references there. You see the 6.30, 6.32, and so on.
Yes, I see that.
So again, if one turns back, for example, to 6.32, which is on page 43 of the PDF.
Sorry, is this the management plan?
No, it's the inspector. This is 6.30, I should say, of the inspector's report, which is PDF page 42. Pagara, getting it, it is clear.
Sorry, I think I've lost you. Can you just say again? So I thought you were referring to okay. So 630, 632, and
Yeah.
and the other references are to the
Yes.
inspector's decision.
Yes. Now, what the inspectors there are doing is referring to submissions that were made by Mr. Warren in that case for the applicant.
Mm-hmm.
And we can look through the submissions that were made. First at 630 on PDF page 42. There's a reference to the inspector's decision, the Chiswick Curve case. And you see the paragraph of the inspector's report that is quoted there. And if one looks at the way that the inspector dealt with that, he says substantial harm could only be caused the heritage asset concerned derived most of its significance from its setting. Difficult to see how very much, if not all, significance of the asset could be drained away otherwise. Think of follies, etc., where a good deal of asset significance would be contained in its setting. On that basis, PPG is not wrong in general terms. However, no one could reasonably argue any of the designated assets that derive most of their significance from their setting. In all cases, by far the greatest part is held in their confines and/or fabric. Okay, I just want to pause there because I want to come back to that in the context of the Summerskill decision. And then the second reference is 632. Second and connected is the issue of limited impacts and asset with multiple aspects to its significance. Concerns expressed that one should not artificially lower the degree of harm on the basis that one aspect of significance is harmed. That proposition is obviously right, etc., etc. Assets rich in significance inherently more robust. So again, that was the case that was being put to the inspector at the time. But if one goes back to the paragraph 1515 that we looked at earlier on, it's quite clear, isn't it, that the inspector is effectively, having heard all those submissions and staying on those submissions, is saying, well, look, no, the key point is actually to focus on what the importance of the contribution made by setting, notwithstanding the submissions that were made. That's right, isn't it?
Yes, and so I think that you've, what I read the inspector to say there is it's not just a quantitative exercise; it's also a qualitative exercise. So, in other words, you may only affect a small part of something, but that may be a very important part.
Yes.
So what's important is the importance of the aspect that's affected. So in other words, it might only be a small aspect, but it might be very important. And so you can't then say, well, the impact is low because it's only a small aspect that's being affected. So that's how I read that. I don't know if I read that wrongly, but that's what I read and what the inspector says there.
Thank you, Mr. Frohnman. And for present purposes, I'm content to proceed on the basis that, well, look, you look at the importance of the setting in terms of its overall contribution to significance, and then you reach your judgment on that basis. And secondly, just because a proposal affects a small part of the setting, you can't simply then say that you're at the low level of less than substantial harm, because there's lots of other factors to be considered, in particular the importance of that part of the setting. Correct?
Yes, that's exactly what I meant when I said the qualitative assessment. So you need to look at the quality and contribution of that aspect that is being affected, and that may be disproportionately high. Conversely, it might not. So it very much depends on what it is that's being affected.
So you take a qualitative, not some sort of mechanical quantitative approach, in short.
Yes, that's correct. Yes, that's what the inspector means by the importance. So you look at how important is that bit that's affected.
Okay, that's fine. That's fine. Now, in terms of 6.30, this point about the relationship between assets that have most of their significance in their physical form. I think the inspector in that case, as I understand it, in Chiswick Curve decision that was referred to at 630, was I think the same inspector in the Summerskill case that we have looked at already. And can we just see the extent to which the inspector followed a similar approach in Summerskill? So if we go to the paragraph that you were taken to in Summerskill, please.
Let me just get that up because I've got many tabs open now. And
it is, bear with me, it's ID 254.
I can't do more than one open, more than one at the same time. So I'm sort of flicking between them.
I'm struggling too. ID 2.54. And I'm looking at it online, but if one goes to PDF, page 97 of 124.
Mm-hmm.
I think this is the paragraph that you were taken to, 1250 in particular. Just want to explore this briefly, the implications of this. I mean, as a starting point, Mr. Flynn, you looked at this already. I mean, I think you'd accept, wouldn't you, that it's not the case that where you have much significance invested in the physical form of a fabric, that automatically takes you to low levels of harm in a setting case?
Well, it really depends on how much significance the asset will derive from its setting, because ultimately you have to calibrate any harm to the significance of the asset. And if its setting contributes only a limited part, only to a limited extent to its significance, then it is going to be very difficult then to find high levels of harm if the setting is affected. It depends really on the nature and contribution of that setting to that significance.
Yes, but I think insofar as 1250 is maybe taken to suggest that, well, you are automatically going to be placed in low levels of less than substantial harm in all cases, unless the asset concerned derives a major proportion of its significance from its setting. You're not going as far to suggest that, Mr. Froneman. It's a question of qualitative judgment in the end, isn't it?
It is a question of qualitative judgment, and that qualitative judgment will have to take into account the degree to which the asset derives significance from its setting, and the degree to which the asset derives significance from that part of the setting that's being affected. It's not saying that you discount these things or that you tot up all the other things which aren't affected. You look at qualitatively how much a particular element or a particular component, i.e. setting, contributes to overall significance, and that's how you calibrate harm.
Okay, and I mean, just to ask one sort of final question on this point. I mean, designations, take listed buildings, for example, will be based essentially on a physical asset, architectural historic interest of that asset, which implies they'll have, extensive significance in their own right. And if you effectively adopt a rule that you must have the major proportion of significance being derived from setting, I mean, it could lead, couldn't it, if you adopt that rule, to some unusual results. For example, if you have, say, St. Paul's, you've got an entire wall of development around St. Paul's, not touching the physical fabric of the asset itself. It would be very unusual to somehow suggest in those situations you're at low levels of less than significant harm, simply because you're not affecting the physical asset itself. That's right, isn't it?
Yes, but nobody's adopting these rules, and nobody sort of, I think again with St. Paul's, your example there, you have
This is a building announcement. The fire alarm system is about to be tested. No action is required. This is a building announcement. The fire alarm system is about to be tested. No action is required.
I don't think they like touching St. Paul's very much around here. Should we wait? Okay.
Attention, please. Attention, please. A fire has been reported in the building. Please leave the building immediately by the nearest exit. Attention please. Attention please. A fire has been reported in the building. Please leave the building immediately by the nearest exit. Attention please. Attention please. A fire has been reported in the building. Please leave the building.
Okay, so let's just. I think it's important. That's a bad. Okay.
They take a while to decide it's over, don't they? Should we? Yes.
Mr. Linus, just to contextualize, because you put a proposition
This
to.
is a building. Testing of the fire alarm is now complete. Please respond to any further alarms. This is a building announcement. Testing of the fire alarm is now complete. Please respond to any further alarms.
That was always going to happen, wasn't it? Right. Sorry,
Yeah.
Doctor.
I just want to respond to that suggestion, which I know you just made a sort of suggestion there, and maybe quite flippantly, but I think that if you were going to build a large scale office block in the setting immediately in the immediate setting of St. Paul's, then I think it might be quite a large visual change and a large change to the setting of St. Paul's, which might not affect its significance at all. But if its setting might well be considered quite important in other ways. So, for example, you have a whole London view management framework which is focused on protecting the setting of St. Paul's, which I think sort of goes towards telling you how significant its setting is and how sensitive. And so, so if you were to build a wall that would interfere with the London view management framework, then I think you will find that you do get into trouble, and that it may be said that you do cause high degrees of harm. So, just responding to that example, I think that's it illustrates how you need to look at it qualitatively and how you need to look at the specifics.
Yes, and that applies even though there's absolutely no dispute that there's massive amounts of significance invested in the form and fabric of St. Paul's itself.
Yes, there's much significance in the fabric of St. Paul's. But that doesn't mean that its setting is irrelevant or that its setting is not important.
Yes, okay. Thank you very much. So you may have massive significance in the physical asset, but by no means precludes huge importance to the setting. Thank you very much. Okay. Now, second thing on approach, hopefully deal with this briefly as well. As far as harm is concerned, you would accept, hopefully we can take this quickly, that one must look at cumulative effect as far as harm is concerned. That's right, isn't it?
Well, insofar as the guidance of Historic England tells you to take into account cumulative, and I know there's different interpretations of what cumulative might be. I use cumulative in the sense that is described in paragraph 9 of GBA 3. In other words, if there is already harmful development, then that doesn't mean that you don't need to consider further development or the harm that further development can cause. And that's how I read it. That's how I read it, and how I understand it, and how I apply it. What it doesn't mean is that if you're proposing something in the setting of a heritage asset where the setting has already been compromised, that you then say, okay, well, here's the harm that derives from this proposed development, and then you add it to the harm that already exists, and that gives you a sort of sum total of the harm that you then cumulatively take into account. What you take into account is the additional harm that would be caused as a result of the proposed development.
Right. Okay. So that's interesting. So just want to look at that then, please. Can we take out GPA 3, please? CD 1022.
I have that.
If we go to page 12 of the documents, the same in the PDF, paragraph 36.
Paragraph 36.
Yes.
Yes, I see that.
Okay. Sorry, ma'am. Just bear with me. I've lost that now. Yes, and paragraph 36 says cumulative assessment required. A purpose to identify impacts as a result of introducing a development review in combination with other existing and proposed developments. The combined impact may not simply be the sum of the impact of individual developments, it may be more or less. So again, I'll put the point to you. You can make submissions about it, but clearly what paragraph 36 is envisaging there is impacts that are viewed in combination with other existing and proposed developments. So it is looking at an accumulation rather than incremental harm, isn't it?
Yes, but that is if in accumulation, the impact is greater than the sum total of what is there and what is being proposed. So that is how I understand that cumulative impact. But just to give you the reference, ma'am, to what I was referring to in my previous answer, you'll find that on page 4 of the same document, and it's under heading it's under the heading cumulative change, which is on the right hand side, sort of in the middle of the page. And so I think if there is a case where the interaction between what's existing and what's being proposed would result in a greater degree of harm than the combination of each, then yes, it's relevant to consider that. I don't think that's the case in this instance, but you may have a different view on that.
Okay, so just to be clear then, I mean, you don't accept on this analysis, as I understand it, the ones looking at the totality of cumulative effect, but you do apply this on an incremental basis, don't you?
No, what I'm saying in terms of this paragraph 36 that you took me to is that if there's an interaction between the baseline position, let's call it the baseline harm, it could be beneficial, but in this case, we're dealing with harm. If there's an interaction between the baseline harm and the proposed harm that would be greater than the combination of those two, then you've got a sort of cumulative scenario as it would be in EIA terms.
Yes, so you would be looking at the totality there, that where there's this interaction, as you put it, you would, when reaching a view on the degree to which harm would arise, you've got to take into account the existing harm and its interaction in a cumulative basis with the harm caused by the proposal.
That's right. So you take the baseline is the existing harm, and you then look at the harm caused by the proposed development. And if there are then any indications that tells you that there would be a greater level of harm because of the interaction between those two, then you can take that into account. As I said, I haven't found such indications in this case.
Okay, but again, just so I can be clear, when one's putting the harm on the one side of the balance, the harm that you put on is not purely the harm from the proposal, but it's the harm resulting from the proposal plus the harm that's existing.
No, because the proposal doesn't cause the existing harm. But if the proposal caused an interaction with the existing harm that would elevate the harm that is caused by the proposal itself, then you can take that into account as a cumulative.
Yes, okay.
So I think I'm clear about that. I think I've answered that question twice now, but if you want to ask me again, I will give you the same answer.
Okay, and just to confirm, if we take out the historic England advice note, please, it is ID 217.
I'm sorry, ID?
ID 217. It's the advice note on tall buildings.
I think I have that in hard copy. Which page is that on, please?
It is on page 8 in the hard copy. Page 11 in the PDF. Okay, so then again, the reference to cumulative development refers to the combined impacts on heritage assets from existing, consented and proposed tall buildings. Again, it confirms the proposition that I put to you that where you're looking at harm, one is looking at the combined impact, which would include those arising from existing and proposed developments. That's right, isn't it?
Yes, and there it talks about consented as well. So if you have a consent, then you will take that into account where relevant. In this case, I don't think there are consented developments which we would take into account. But typically, that's the sort of thing that you would do in an environmental impact assessment, where you would look at you would typically have cumulative views, where, for example, you would show the baseline, the existing, you would show the existing with a proposal, and then you would show the existing with a proposal and the cumulative schemes as they are sort of coming forward. That's typically how you would deal with that. What I don't accept is that that if there's a baseline situation, so in this case, I'm just going to, just to be clear, I'm just going to illustrate that with an example. So, for example, where you have the buildings on the Great West Road being visible from Syon Park, what you don't do is, and I didn't see Mr. Stroud doing that either, is to say that the proposed development is going to cause a certain amount of harm, and then you say, okay, but we don't stop there. We then also say, but there's already existing harm, and you add that to the proposed development to arrive at the level of harm that's being caused. That harm that's already being caused, that's part of the baseline.
Right,
and so you don't take that into account unless, as I've said previously, there's a specific indication of an interaction between the baseline harm and the proposed harm that would elevate the degree of harm arising from the proposal.
Okay, so I think your position is that you would look at it in terms of totality, where as a matter of judgment, it's thought that there should be an interaction, in your terms, between the existing and the proposed development. But you would be looking at it in totality terms then, wouldn't you?
What you would then count is the additional harm that arises from that interaction. You don't count the baseline harm because that's the baseline. What you count is the additive harm, the cumulative harm, the accumulation of harm.
Yes,
that accumulation in that context would be A, the harm that's being caused by the proposed development, and B, the additional harm, the accumulation of harm that's being caused by the interaction of the proposed development and the existing baseline.
Right. Well, I mean, that's not Mr. Froneman actually assessing the cumulative effects of the existing and the proposed scheme, is it, in a combined way? Because you're effectively treating the baseline as something neutral in the assessment.
But the baseline is neutral in the assessment because the baseline is what exists. If the baseline, if you look at a building that's already harmful, then in accordance with the setting guidance, of course, you would look at the additional harm that would arise from the proposed development. But what you don't do is you then say, well, you take the proposed development and you add to that the harm that already exists to arrive at a sort of the answer as to the harm that's been caused by the proposed development.
But
So in other
that's-
words, let's just think about it in this way. So if you've got a building, a listed building, and half of it's been demolished in the past, that's caused a lot of harm, but you still have half of it left, and you are proposing to knock out a wall, and that causes some harm. You're not going to say, okay, well, there's the harm from knocking out the wall, but really you add to that the harm that's occurred in the past from knocking down half of the building, and that's the harm that you arrive at. You take into account the baseline as it is.
Okay, well, I mean, I have to say that's a proposition which we don't accept in general terms, given the guidance that I've taken you to. I mean, this was an issue that was debated at the Citron inquiry, and I mean, perhaps we can just take out that decision letter briefly, please. CD 9.1 again. Paragraph 15.29 on PDF, page 130. Okay, do you have that? PDF page 130, 1529. Now, the inspector says cumulative harm should be assessed in 3 ways. Proposed should be assessed initially, followed by a cumulative assessment. Reference to the earlier version of advice note 4. Which of these considerations carries more weight? How these combine with matter of decision maker based on circumstances? Existing harm should never be used to justify additional harm. Policy is unequivocal. The quantum of proposed harm should not be compared with existing harm in assessing whether it makes a significant difference. And there's reference to a tipping point. And at 1530, it goes on to say, in the circumstances of that case, to see what was done, refers to Haverfield Towers have a greater impact in the setting of the WHS as a whole over a much wider area. Taken with existing impacts and for similar reasons, I find that overall there'd be a minor cumulative effect. Combined with the impressive credentials, the weight, slightly greater cumulative harm should be assessed as a little bit, not much more than moderate, well short of a tipping point. So, I mean, in that case, clearly what the inspector did was actually to take existing harm, take the harm resulting from the proposal, and reach a position based on the cumulative impact. He was not, because it was an issue that was being raised at the time, simply looking at an existing baseline and judging whether or not there was incremental harm being caused to it.
Yes, but if you read the preceding paragraphs, you'll see what the context is of that, because what the inspector there was looking to do is to see whether the proposed development would tip the harm into substantial, which is a different test. So the inspector needed to know whether the test that needs to be applied was that of substantial, less than substantial harm, whether in terms of the harm that's been caused to the World Heritage Site, which was the allegation put in front of the inspector. And so what he finds is, if you combine those two, then it's still less than substantial.
Yes, but the overall approach was to combine the existing harm with proposed harm. And I mean, in that case, the difficulty that was being acknowledged is that if you take a baseline effectively as your starting point, you would be adding harm to a series of successive baselines if harm's caused in cumulative schemes without ever properly acknowledging the harm that existed in the first place.
Yes, but what they were debating there was the tipping point, which is what the inspector talks about there, the tipping point. So the inspector wanted to determine whether this new development would create a tipping point.
The concept, though, is relevant beyond the question of whether you tip into substantial harm, because cumulative impact has to be assessed on any basis, even if you're in the realms of less than substantial harm only. So, as a matter of principle, Mr. Froman, the approach is that there are fundamental difficulties in effectively taking existing harm as your baseline, because if you do and you treat that as your starting point, you'd be successively adding proposals to a rolling baseline without ever properly acknowledging the harm that was there.
Well, the difficulty I have with that proposition, Mr. Linnes, is that your baseline then that you use to calibrate the harm against. So in the case of Sion, I'm going to just use that as an example, would be Sion absent of any development that you can see beyond the boundaries of the park. That would be the logical. I don't know if you would, in your mind's eye, remove from that the hotel in Sion Park. I don't know how it's in fact possible to even do that, to say, okay, at which point do you reinstate Sion Park 2? Do you look at the 1865 OS maps and say, okay, well, that's what Brown recorded, and so we're not going to take into account all these other harms that have happened over the years. Are we gonna assess the harm against an idealized version of the park, which doesn't exist and hasn't existed for many years, and you measure the harm against that? I don't understand what it is, how it is that you determine a correct baseline if you are using a baseline that doesn't exist, an idealized version, as what it is that you're measuring impacts
There'll
against.
plainly be a matter of judgment in any case, but for example, in the Citron case, the Haverfield Towers was acknowledged to be a detractor. And the issue that was being debated there as well, if you started adding stories on the top of Haverfield Towers, do you treat the Haverfield Towers as existing harm as a baseline, or do you take that into account as part of an overall assessment of cumulative harm? So Haverfield Towers was a point there. There'll be a question of judgment in any individual case, but it may be possible to identify that some schemes are detractors in the scene, and you take those into account. So that's just a matter of judgment. That doesn't affect the principle, Mr. Froneman.
Well, no. The difficulty with that proposition is that there's absolutely no. There's no guidance. There's nothing to tell you what it is that the baseline should be. If it's your judgment that you take into account X, Y, and Z, but you don't take into account A, B, and C, and that's your judgment, and you base your cumulative assessment on that. I mean, you might have 10 different consultants doing 10 different assessments, and they all take into account different things as a baseline, because there's nothing to tell you what the baseline should actually be.
That's no different than any assessment of heritage harm. There'll be matters of judgment that have to be made on impact, on harm, anything. But the point of principle, Mr. Froneman, is that if you effectively if you treat the existing situation as the baseline, you acknowledge the risk, don't you, of there being an ever-developing baseline where the harm that's been caused before is never properly taken into account. And you risk death by 1,000 cuts, to put it in those terms, because there's no proper recognition of the harm.
Well, no, I disagree with you. And that's exactly why on page 4 of GPA 3, you've got that section headed cumulative change, which is the one that you don't need to turn up, madam, but that's the one that says where the significance of a heritage as it has been compromised in the past by unsympathetic development affecting its setting to accord with MPPF policies, consideration still needs to be given to whether additional change will further detract from or can enhance significance of the asset. That's saying you don't discount that and say, well, I wish it never happened, and we're just going to ignore it and think of it as not being there. And then when you do the impact assessment, you then take it into account and you say, well, that's somehow part of the impact of the proposed development. It's not. It's the baseline is the baseline. Whether that's unfortunate, whether that's harmful or not, that is the baseline, and that's the starting point. The baseline is the starting point for your assessment.
Okay, let me just test it in this way, because I'll probably cut a number of questions short when it comes to Sion. I mean, if one takes, for example, Sion as one example, there's been the QI, other tall building development that one can see beyond the boundary. Do the exercise that you have suggested, that you imagine in your mind's eye that existing tall development modern tall development outside the boundary of Sion Park isn't there. Okay. Would that affect your judgment on the level of harm that was caused if you accumulated that with the proposal?
Yes, it would change
it
it, because
right.
if you imagine yourself that there was no modern development, there was no hotel in Sion Park, that the garden centre didn't exist, that the tall buildings on the Great West Road didn't exist, and you then measure the impacts of the proposed development against this idealized version of it, then it would be different. But I will just remind the inspector again of what it is that setting is. And setting is not an idealized version or a version that can be traced back to a certain point in time, and that's the starting point for your assessment. Setting is the surroundings in which a heritage asset is experienced. And if your experience includes the towers that are on the Great Western Road that you experience as part of the setting of the park, then that is part of the existing
Yes.
setting of Syon Park.
Okay, but then
And it is
if
then
you-
against that you measure the impacts.
Okay, but if you follow that analogy, say these proposals are granted permission, someone else comes along, right? The baseline you've got to look at is QI development proposals here once they're built. Another inquiry, someone says, well, actually, you're going to have to look at harm against the existing baseline with all these developments in place. You'd have absolutely no control over, absolutely no way in which you could ever sort of pitch a proper assessment of harm, because you'd never be taking account of the development was already there.
But you do take into account the development that's already there, because the setting guidance tells you to do that.
Yes, but you're
And
not
that is-
feeding
that is-
that. Sorry, Mr. Freeman.
I'm so sorry, but that is what you take into account. That's what the guidance tells us to do. There's nothing that I could see in the NPPF that tells you to take back when you do an assessment of harm to heritage assets, and that's harm from setting, and harm can also derive from physical impacts. There's nothing that I could see in the NPPF that tells you to do a sort of this mental gymnastics that you're talking about in envisaging something that doesn't exist and then measuring impacts against that something that doesn't exist. I see your, I can understand your position that you feel that it's very unfortunate that there is already harmful development in the setting of Syon Park. I will agree with you about that, but that doesn't mean that you can roll back the clock. It doesn't give you, it doesn't mean that the baseline then changes to something that you would like it to change to. The baseline is the baseline.
Very well, I think I can make submissions on that on the basis that you accept that if there's existing harm caused to the understanding of Syon Park by existing toll development, including the eye, that would actually change your judgment on harm if it's treated on the cumulative basis that we've assessed.
I didn't catch that last bit. I'm so sorry.
I'll operate on the basis that you have taken the baseline as it stands, and that your judgment on harm would change if you took into account as well the harm that's caused by existing modern toll development in Brentford.
Yes, that's correct. And then in that case, madam, you would have to decide for yourself whether it is possible to arrive at a baseline of sorts which you can usefully define and which you can usefully use and operate on within the policy and the guidance that exists.
Yes.
I don't think that that is possible, but if you disagree with me, ma'am, then I suppose then you can follow that approach.
Yes, and if that's right, the conclusion would be that you underestimated the harm caused to Syon. That's right, isn't it?
Well, if the approach is to ignore the baseline and to discount your experience of the setting of Syon Park, then I suppose you could say that yes, and if you then, I suppose the other part of that if you then count, when you look at the impact of the proposed development, also the impact of things which have happened decades ago, if you take all of that into account when you look at the impact of this proposal, then yes, it would be underestimated. But that's on the basis that, first of all, you ignore the baseline, and secondly, that you don't count the harm that arises from this proposal on its own, but you count the harm that arises from this proposal on its own against along with all the other harms which have occurred over the years, and you add that together, and then you arrive at some super harm. In that case, yes, I would have underestimated the harm, but I don't recognize that approach, and I don't think that's right.
Okay, well, I can make submissions. I don't want to spend any more time on that, on how your approach sits with what was effectively established, we say, through Citron and other cases. Okay, let's move on, please. Just deal briefly with Austerley. As far as significance and setting is concerned, I think in your proof at page 210, oh, sorry, paragraph 210.
Yes, I have that.
You say, you talk about the illusion of the designed landscape or park in this location being set in rural or Arcadian surroundings being broken by the suburban fringe that you refer to. I mean, as far as the heritage significance of Austerley is concerned, I mean, it follows, would you accept that the design intent of the park was to create what you had described as the illusion of the designed landscape in this location being set in Arcadian surroundings?
Yes, but you need to
Yes.
also then read, I think, the first sentence that I've put there, and I think this is relevant actually to the debate that we just had. So there, what you have there is you have a harmful change to the setting of the park. In
Yes.
other words, the bit of the development that is now a heritage asset included within the conservation area. So on one hand, you have the park, which was there first, and it had its Arcadian setting, and then you have the protected townscape within the conservation area, which has caused harm to the setting of the park, but that's now encapsulated as part of a heritage asset that includes the park itself.
Okay.
But
I think yes, sorry, Mr.
yes,
Miller.
to answer your question, I suppose your question was whether the design intent was for this park to be Arcadian. Well, I think in a sense the answer is yes, but I would go further, because there was no need really in a way to design the park in that way. Because if you turn back to the OA's maps, and I think I've got a copy of it, I just want to see if I can lay my finger on it. And yes, I can. Figure 3, page 20 of my proof map.
Yes.
And so that's about 100 years after the creation of Austerley Park. So it's not the original setting. We don't, unfortunately, have a map that records the original setting of the park. But in a sense, what you see there, madam, is that there was no real need to design an Arcadian setting to the park, because there was an Arcadian setting to the park, because around the park there was an absence of development. And so you're talking about the design intent. I think that the design intent, in a sense, it was unnecessary to design a sort of Arcadian hinterland to the park, because that was what existed at the time.
Okay, that's the design intent of the park, insofar as the inquiry has in front of it views, including view M in the CD 1051 document. This has the development superimposed, but we can get an idea of the sorts of views of the parkland under view M. Page 59 of that document. Views across the parkland from that location give an understanding of the designed pastoral character of the parkland. That's right, isn't it?
Well, in the sense that you now have a tree line that encloses the park,
Yes.
and that sort of that shields out, if you like, to an extent, the surrounding townscape. But there are a couple of points that I would just mention, because these are relevant. The first being that well, they kind of merge into each other. Well, I'll start first with this visualization that you took me to, because this is a this is a cropped version of the actual visualization that was done. But of course, the actual visualization that was done is done from a particular point in the park, looking in a particular direction. And it doesn't encapsulate the experience of what you understand when you're looking there. And that's at a junction of the two footpaths. So you sort of get this footpaths going off in different directions. So you're well aware of what goes on beyond this particular sample of that view. And so you're well aware of the other buildings, the other modern buildings, which you see beyond the park. And indeed, you can see in that particular view the houses that you see through the trees. And man, you've been on site, you've seen those, they're visible there. And you've had the wider experience of wandering in that part of the park and seeing what you can see from there. And so I think it all has to be in that context. And so the change to that view is not, it's not simply by looking at a two-dimensional snippet of what you see and experience when you're standing at that point. There's a wider experience, and you have to put that change within that wider experience.
But in those views, they demonstrate, don't they, the use of trees on the boundary was to encourage views across the parkland whilst providing a sense of enclosure and separation of the estate. It's fair, isn't it?
Yes, and you can still see that, even though there are many places where you see things beyond the boundary trees. You still experience that. It's not very difficult to read the boundary trees as inherently part of the park. But what you also see when you look at the boundary trees is you can see where the park begins. Well, you know where does the park begin? You know where you are, and you know where the park ends in relation to where you are, because you can see the boundary of it. And the boundary trees give you an indication of where the park ends. And then what you experience alongside that is what happens on the other side of the boundary trees. And in some views, you don't see very much, and in some views, you see quite a lot. Your experience as you move around that part of the park, just because the townscape has evolved so much, is that you see the suburban houses, you're aware of the suburban houses, and you're aware of other modern developments beyond the park. And so it's very clear to you what is inside the park, what is outside the park, and where the boundary of the park is.
Yes, I think in fairness to you, Mr. Freeman, you do describe that that development as harmful, don't you, in your proof?
Yes, and I think that goes back to the debate that we had earlier.
Yes.
Insofar as, do you take it into account? Yes, of course you take it into account. Does it mean that you ignore it and wish for a baseline where it doesn't exist? Well, no, you don't do that.
And you accept that it is harmful because it interrupts the original sort of design intent of the park and the perception and experience of the park as this pastoral character that you've mentioned in your proof.
Yes, but now that very same development, or some of the same development that has caused the harm, is now part of a heritage asset. So there's a kind of tension between these two things. So you can't just go now, and even if you own them all, you can't just go and demolish those houses in the conservation area immediately beyond the park, because they are now protected. They are now heritage assets in their own right. So in a sense, they caused harm, but they are also valuable in their own right. They also, you can see the Gillette Tower from the park, and that's a sort of a tall element in the distance. Now that's listed, that's protected. You could say, well, that's introduced something beyond the park, which is unfortunate or which is harmful, but that in itself is now protected. The Tesco scheme, if it comes forward, well, it's only an outline. It might be an exceptional design. It might, in years to come, become listed in its own right, in the same way that these suburban houses have become heritage assets, and in the same way that the Gillette Tower has become listed. So, it's not as simple as saying, well, that's caused harm, and so that's terrible, and you wish it wasn't there. What's caused harm is also now a heritage asset.
Well, but I am just asking about the words that you use in your proof. I mean, again, this probably comes down to the debate we've been having. On our analysis, you would need to take that into account as part of a cumulative approach to harm. On your view, you've acknowledged that there's harm, but you effectively treat that as a baseline. It's fair to say the answer you gave to me before is that, I mean, if you're wrong on that approach, you'd accept in this case you'd have underestimated the harm as far as Australia is concerned as well, haven't you?
Yes, but in that case, I think the inspector's got a real dilemma, because then the inspector has to imagine in her own mind, on one hand, that in establishing her own baseline, she has to demolish part of the conservation area in order to get to a situation where the harm doesn't exist, that the buildings in the conservation area, part of the conservation area, part of its character, now needs to be wiped out of history in order for her to arrive at some sort of baseline. That shows you how arbitrary it is, that this baseline that you want to establish, which there's no guidance, there's nothing to tell you, where do you draw the line? What is your baseline? But the inspector's dilemma is to demolish houses in a conservation area in order to arrive at a baseline, and then she can add those houses back in and count them as harmful when she looks at the effects of this development, which is far beyond these houses. The logic escapes me. I'm so sorry.
Okay, but, but you don't find any difficulty in acknowledging that harm has been caused by this development, even though it's within the conservation area, do you?
No, I don't, because
No.
you get that tension. You know, I was working on Bedford Square the other day, and there you see Centre Point popping up behind Bedford Square, and you can look at it on one hand and say, well, I wish Centre Point wasn't there. I wish it didn't interrupt that. But of course, Centre Point is Grade 2 listed, so it's not as simple as saying, well, let's just wish it wasn't there and sort of imagine you can take it away. Because that's not the reality of it. What you need to take into account is what you experience. And for the reasons I've explained, these houses have caused harm because they've eroded that. They've added a developed edge on the edge of the park, which you see through the park, and which has now introduced this built form, which I describe as harmful.
Okay, thank you. Ma'am, might be a convenient moment.
Thank you. 10:38. It's not 10:38. It's 11:15. If we take a break until 25 to 12. Thank you very much.
That's really where the debate is.
couple of brief points on Austerley, and then some other brief points on Kew and Sion, please, Mr. Fruneman. As far as Austerley is concerned, I mean, we've looked at View M already, but I think you'd accept, wouldn't you, that views would arise of the proposed scheme across a wider area of the Eastern Parkland. Obviously, you won't have this viewpoint, but the views would be available from across a wider area of the parkland, right, isn't it?
Yes, and that wider area is the area, excuse me, the area to the east of the historic core, or the pleasure grounds as I describe them, and sort of in a sweep towards the Southern Drive.
Yes.
So that's the area that we would get the views from.
Okay.
And there's that glimpsed view that you would get from within the park through that gap, which I think we've discussed before, but that is the areas where you would see the proposed development from.
Yes.
And just to finish off, those are the areas in which you can see other things like, you can see Wembley Park Stadium, and you can see many other tall buildings and peripheral developments. So that's the context in which you see it.
Okay, I'm not going to reopen that debate again, Mr. Fruneman. We can make submissions on it. But in the context where you accept that there's already some harm being caused by more modern development outside, you accept, wouldn't you, that as far as tall building development in these views that we've been looking at, View M in particular, is concerned, you'd be looking at development at much greater proximity and height than other tall building development that is viewed from these parts of the site?
Well, no, you say much greater proximity, and I don't, the other developments on the Great West Road, you can see at various distances. I think in relative terms, I would describe it as sort of there's two layers, if you like. The first layer is the suburban development that you see around the park, on the periphery of the park, and then beyond that, you see taller buildings at various distances behind that sort of layer of suburban development. And I think, you see the turbine on top of the Sky campus, for example, which is just behind the Tesco site. And so, in relative terms, it's not necessarily that the distance is so much closer than the Sky campus, which in places you see the Sky campus itself. So the proximity, I think, is in relative terms less relevant here, because it's that sort of layer where you can see the immediately surrounding townscape and then the townscape beyond that. And the second point that you put to me was that it's going to be taller than anything that exists at the moment. Well, it depends where you look, really, because if, for example, you look at other parts of the park, then you see all sorts of other tall buildings, not necessarily in the direction of the Great West Road, but there are other tall buildings which you see in different points along the park. So I don't know that it's necessarily going to be taller or much taller than those in comparison. But yeah, sorry, that's I think that answers your question.
Sure, but certainly in terms of the views that we're looking at, View M, it is going to be noticeably greater scale of development in views looking out from this part of the park. That's right, isn't it?
Greater scale than what?
What's there at the moment?
Well, was there the moment? I don't know if when you say was there the moment, whether you mean if you just turn, in your peripheral vision on the right-hand side of that view, for example, you see much closer to you, much more of the suburban development. It takes in a much greater part of the view. It's much more immediate in terms of the experience. It's got a much stronger influence on how you experience it. And so, yes, you would see this at a considerable distance at this point. You'd experience it as some, considerable distance away from the park. And then on your right-hand side, you have a sort of quite a harsh edge and quite a long extent of it, which, by comparison, the proposed development would be actually relatively small. So it really, I don't think it follows that it's a tall development and it's some distance away. So therefore, it must be that it's highly prominent or that it's more harmful than what you see on the edge closer to you, and which takes up much more of your experience.
Okay, well, again, matter of judgment for the inspector having regard to all the evidence that's been submitted. As far as the piers and lodges are concerned, just very briefly, I mean, as far as their value is concerned, I mean, you accept they had value as features which help to stress the enclosure of this parkland estate and views from the drive.
Well, no, I don't think so, because I mean, let's turn up the view from the drive, because I think that let's look at what you actually, the proposition that you're putting to me, and ma'am, you'll find that at view O. I do remember standing there on site. You'll remember that. I'm looking at the CROT version, which is on page 61 of, well, that's the site version of it, of the visualizations. Have you got that, ma'am? So the proposition that you put to me is that that these lodges give enclosure to the park. Well, I don't think that they do, because if you're talking about how you perceive the edge of the park and what gives enclosure, the enclosure is given by the belt of trees that you see there, and the lodges stand sort of in front of the trees, if you like. They don't themselves provide enclosure really so much as the trees that you see there and that you see elsewhere. That's the question you put to me. That's my answer.
Okay. I think ultimately the difference between yourself and Mr. Stroud is partly all the influence of the layered landscape, which we've covered before existing development, and partly in the extent to which the proposals are going to risk drawing the eye away from the lodges and the piers. I mean, Mr. Foneman, if one's looking at this view in particular, the scale of the development over to the left is going to cause some risk of distraction, is it not, to views looking towards the piers and the lodges?
No, not at all, because you've got a very defined linear view looking towards the lodges there. If anything, if there's something that distracts, it's the tree that you see on the right-hand side of that view. I mean, that to me is a sort of almost dominant feature in the view, and the thing that sort of really, to some extent, distracts from what you see in front of you. But you've got a very channeled linear view. It's very specific. I don't see the proposed development. I mean, you'd be aware of it, but I would describe it as peripheral rather than something that your eye is going to be drawn towards, and that's to such an extent that you can't really sort of see the lodges, or that you struggle to understand what you're seeing, or that you can't really sort of hold them in your mind because your eye just keeps going back to this development. You'll be aware of it and it'll be peripheral, and that is it. But I suppose the other point to put to the inspector is just, first of all, the significance, how much of the significance of the lodges can you read, and what is it that is significance about what you see, what is it that contributes to significance in what you see there? And I suppose the old conundrum of what it is that if the inspector is going to roll back the clock to some point, some undefined point in time, I mean, does she roll the clock back to 1865 when the lodges were much smaller and when there were trees behind them, or where does she roll the clock back to? I mean, I'm not here to ask you questions, but I'm just putting the proposition to the inspector that I think if you are going to take that approach, madam, I do wonder what it is that you're going to envisage in your mind that you're looking at.
Okay, now if we move away from Austerley, please, just a couple of final points relating to Q, and one final point on Sion. I'm not going to go through Q because I've raised that we've heard evidence from Mr. Stroud, as well as questions were put to Dr. Mealy. I just want to check your position as now updated on Q, because obviously, as you said in your original proof, you accepted that there would be harm caused by reference to MSE 1, the view taken near to the shelter, as well as the southern extent of the Sion vista. I just wanted to check the basis upon which you accepted that there would be a low level of harm. So in your proof at 3112 on page 83, there, based on that viewpoint, you said it'd be experiencing a glimpse kinetic view adjacent to or in the context of the modern shelter. And say, insofar as this would erode the sense of the secluded designed landscape that's largely devoid of modern influences, this would detract from that, and you qualify that judgment. But it's right to record, isn't it, that insofar as there's a difference between the parties on what could be visible, at the time you accepted that if you were able to see the proposals from that location, there would be harm caused by erosion to the sense of secluded designed landscape. That's fair, isn't it?
Yes, I think that's fair, but I think let's just put that in context and look at what it is that Mr. Spence showed in his visualization and what it is that would actually be visible. And I think, Madam, I'm going to ask you to turn up Dr. Mealy's rebuttal on page 10 of that. I don't have the CD reference or the ID reference, I'm afraid. Rebuttal appendices, I think they're all bundled together. I'm afraid it's going to be a long answer, but I just want to make sure that you understand my position, ma'am. So I'm going to refer to other documents as well, but I'm going to start with this one. So what I've got, Dr. Mealy's rebuttal, is on page 10. There's at the top of the page a small photo of Mr. Spence's view 1, and then at the bottom there's a photo of what AVR London showed would be visible from there.
Sorry, Mr. Finnan, which document are you in?
Appendix 2. I'm so sorry. Maybe I gave the wrong reference. I'm so sorry. And it's page 10 of that document. That's it. That's it. That's it. So, so the one at the top is what I based my assessment on when I said I just want to find the actual words that I used. An effect that is very slight indeed, nearly altogether negligible when considered on the whole, though harmful nevertheless. So nearly altogether negligible. And I think if I compare what you see on the AVR view and what you see on Mr. Spence, I think that removes the nearly altogether negligible and it makes it negligible. And I suppose I'm not going to ask you to turn up these documents, but we can go to them if we need to. And there are two things which I think is perhaps relevant to just to note, and that is that the World Heritage Site Management Plan talks about the Zion Vista and that new development visible from there would shatter the experience, I think is the words that's used. And of course, Madam, you will have seen my rebuttal proof, and you can see that there are, in fact, as a matter of fact, development visible, albeit not very much, from the Zion Vista. Now, in the same way that the World Heritage Site Management Plan didn't recognize that, didn't find that there's anything to say about that, didn't find any harm to say to mention that. In the same way, I don't find any harm to mention about what may or may not be visible in that view 1 of Mr. Spence. And that's my answer.
Okay, but obviously we've got the evidence of Mr. Stroud, but on the basis that you had thought that there was some visibility of the scheme at the time you wrote your evidence, the basis upon which you're accepting harm to OUV was that there would be an effect on the sense of a secluded designed landscape. That's right, isn't it?
Yes, that's
Yes.
right. And my words were nearly altogether negligible, but
Yes, okay.
nevertheless harmful.
Nevertheless, and I think again, just to check the position in your proof on page 76 at 3.83. You're referring to a wider area, such as the one seen in view AH. You refer to open pockets. You say there's boundary planting along the Thames path, not impermeable. There's a clear sense of separation between the gardens and the landscape beyond. Just wanted to check the position. I mean, when you say they're not impermeable, you said it'd be filtered views of Sion House. Again, is that position affected by the work that you've been referring to? That you've accepted there may be other open pockets within the wider area that aren't impermeable and may offer some filtered views of Sion House?
No, let's just. There are two things that I need to clarify.
Right.
One thing specifically that I need to clarify. I think because I refer to it, I want you to turn it up, view AH, and that's in the bundle of views. I'm so sorry, it's page 79. I'm again looking at the cropped view for site visits. And so what you see there, in front of you is the open pocket. So in other words, what I'm talking about is that there's quite a lot of sort of woodland planting in that area, but there are pockets where it's a bit more open, but it's not open to the boundary, where the boundary is still very much screened and separated from the surrounding townscape environment. And I'm specifically referring to view AH as an example of that. And we've turned it up, you can have a look at that. And I don't think that, to the extent that there may be some very filtered views of very small parts of the proposed development visible in such views, I don't consider there would be harm to the World Heritage Site, the outstanding universal value of the World Heritage Site, because of the nature of that separation and the understanding that there's a separation. And I suppose coupled with that, the fact that I don't think, unless you really, really sort of looking for it, you would actually be aware of the proposed development in such views in any event. It's very, very difficult to see through that screen. You might get some sort of sense of it it's really when you're walking around and the effect of motion parallax means that development in the background sort of moves a little bit, then you might see something. And in the same way that you see some of the buildings on the Great West Road, it's very difficult. I mean, sometimes you can't distinguish them. You just, there's a shape, but you can't really say much more about that. That's what I'm referring to there.
Okay. Well, thank you for that clarification. So the judgment for the inspector then is that insofar as you accept in relation to other glimpsed views in this area, that the issue would be the erosion of a sense of a secluded designed landscape, largely devoid of modern influences. To the extent that there is any visibility elsewhere, it would tend to engage the same considerations, wouldn't it, Mr. Froneman?
I think if you look at view AH, what you see there is exactly what I described, the sense of a secluded landscape that is devoid of, or largely devoid, I think is maybe what I said, of development beyond. And I think that you with the proposed development in place, you can describe that in similar terms. And so that's why I'm saying that there's no effect. It's not going to make that description of what you see in that view any different.
Okay, but that would be the nature of OUV that would be potentially engaged for the inspector to decide the potential erosion of a sense of secluded design landscape.
Potential erosion, if the inspector finds that what you see in, example view AH does that, and that it erodes the OUV. I mean, I have to say, I didn't see Mr. Stroud making points about view AH, and I think it's obvious why he didn't. But I would just sort of put a marker down there that Historic England didn't take a point with view AH as far as I remember. And so I think that there's actually broad disagreement that there's no harm from what you see there, and similar views.
Okay. Right. Just a couple of final points, please. Thames Path, I'm not going to go through that in terms of the debate that's been had on Mr. Stroud's on one part and Dr. Moody on the other. But just to draw the inspector's attention to committee report from the council, CD 5.2, please.
Bear with me.
And it's PDF, page 90.
90.
Yes.
I have that. I just want to see if while you get that, ma'am, I probably have a marked up version that I can find that might take me a little bit longer, but which might be more helpful to me. So
yes,
while you do that,
and this is the exception where it's helpful to have a PDF because it's the usual form of committee reports, not paginated in the hard version, but it's 90.
this is the one for Tesco, is it? Or is it Homebase?
Let's just see. Homebase.
Homebase.
8224.
I'm going to look at the one that so 8224, yeah.
Yes. There's a description of the gardens, which you don't need to go through. And towards the end of that paragraph, it says, more widely, the tree-lined riverbank and neighbouring parks and gardens in Kew and Hampton Court form part of a landscape referred to as the Arcadian Thames. This stretch of the river has idyllic character, etc., etc. It says the proposed development is not located within WHS buffer zone, but owing to its tall buildings has the potential to affect the setting of the WHS beyond the buffer zone, and so indirectly it could affect the significance of the various heritage assets at Kew. Plainly, the officers there were recognising that ultimately there was the potential for Kew to be affected, even including views from the Thames Path.
No, I don't see that. I think you're jumping to conclusions there, and that's certainly not how I read that. I certainly don't see anything that says anything about impacts from the Thames Path. What it says in the last sentence is the proposed development is not located within the World Heritage Buffer Zone, matter of fact, matter of agreement. But owing to its tall buildings, it has the potential to affect the setting of the World Heritage Site beyond the buffer zone, matter of fact, matter of agreement. And so indirectly, it could affect the significance of the various heritage assets at Kew. Matter of fact, matter of agreement. Yes, if it was visible alongside the various assets at Kew, then it could cause harm potentially, but that's not the case.
Okay, very well. And then finally, just when we're dealing with the report, if we go to 8220, please, sorry.
Sorry, same report, 8220.
It's just a few paragraphs up. Now, bear with me. Yes, this relates to Sion. And the conclusion is reached there. There'll be greater impacts on the historic park and landscape to the west of the house.
I'm so sorry. It's a long paragraph. If you just
Yes.
direct me to where you are.
Yes, I'm just looking at the start at the moment. But
I'm with you.
If you look down 7 or so lines where it says cumulatively.
Yes, I have that. Do you want to read that out? Shall I
Yes,
read it out?
Cumulatively, there are already some harmful impacts on significance from buildings within the setting of Sion Park. These mostly at the eastern end, although winter-built development is visible along the northern edge of the park within and above the tree line. Visible modern intrusions include the Gillette Tower. The introduction of new built forms in the setting would be detrimental to the appreciation of heritage significance. Magnitude change are low to moderate. The Tesco proposal increases this harmful impact and cumulatively increases the harm to moderate, less than substantial harm. Now, again, we can deal with this in submissions, but plainly what the officers and the council were doing there was treating cumulative harm as encompassing existing harm from existing modern development outside the park. That's right, isn't it?
I don't see that the officers there have quantified in any sense cumulative schemes, and I don't see any exercise where that has been quantified, put aside, and then added to the harm that the proposed development would cause. What I do see is that the officers are treating the Homebase scheme cumulatively with the Tesco scheme, because that you can see in terms, and that's right, because then you have these two developments together, and they in fact form part and parcel of a singular development, as I understand it, neither of which would come forward on their own.
There's no
But
issue with that.
I'm so sorry, but what they say in terms there, I'm sorry, I just want to finish that point. What they say in terms there is that that the harm that arises from the Homebase would be added to by the harm from the Tesco scheme. But what they don't then do is they don't then say, okay, you've got Homebase, you've got Tesco, and then added to that, you're going to add the other harm from the Great Western Road, which I don't see any of that. I mean, that seems to me what the rationale of your questioning earlier, and it seems to me that if I made the mistake, then officers made the same mistake.
Well, no, the reference to cumulatively there are already some harmful impacts on significance suggests that officers did take into account as part of the cumulative approach to harm the fact there's already harmful impacts on significance from buildings within the setting.
In exactly the same way, yes, exactly in the same way that I've said that there's already harm to the setting of Sion Park because of the existing developments. Is it already harm to the significance and setting of Osterley because of the development that's there already? That's acknowledging what's there. That's acknowledging the baseline. That's doing what you should be doing. What the officers, I'm so sorry. What the officers didn't do was they didn't say, here's the quantity of harm that arises from those cumulative developments, and we are now going to add that to the harm that arises from Tesco and from Homebase. And if I might just finish on that, if they were to do that, I do wonder whether they would also then take into account, would they also add the benefits of those schemes? Would they also take into account the overall planning balance and then say, well, there is also harm from QI and from Great West House and from GSK, but those developments also have their own benefits, and we're going to take that into account and roll that into the planning balance. There's nothing to say that. I mean, I don't see that they've done what you suggested I should be doing, and I didn't see Mr. Stroud doing that either.
Okay, thank you very much, Mr. Funman.
Thank you. So do you have some questions for this witness?
No, ma'am.
Oh, okay. I've just got a couple. Just a minute, question I asked Dr. Mealy about the existing Homebase development and designation as a non-heritage designation as a non-designated heritage asset.
I'm
So
with you,
you-
ma'am. I do have the answer, and I've written it
just
down.
first of all, your 121, 1.21 and 6.1, both those places. No, it's not 121. Let's try 6.1 then. No.
Is it 6.15?
The places I've written it down is wrong. Anyway, you refer to it as a non-designated heritage asset. Yeah.
That's right.
So yes, is it on the council's list? as a-
It's not. It's not on the council's list, as I understand it. And I think the reason why it was identified, and you'll be familiar with the process, madam, that usually we think of non-designated heritage assets as locally listed buildings, but it's also been found that a building doesn't have to be locally listed to be a non-designated heritage asset. It only needs to be, the council needs to ascertain for themselves that it's got enough interest to be one, and then they need to identify it, and both of those things have been done. If I may just add, I think the background to that is that there was a listing review of the Homebase site before the applications were put in. I think it was before, not during, but the building was reviewed at that time for listing, and it didn't make the grade for listing, but Historic England, in their review of the building, found that it did have some interest in the sort of high-tech movement. It was designed by Nicholas Grimshaw, and so there was a degree of interest in that sort of technical design of the building, and so that's why it's been identified as a local, as a non-designated heritage asset.
Yep, I understand that. I've seen the Posner reference to it and the architect's description of it that was in your evidence. So your 5.27 and 5.35, you say that there is nothing positive that can be said about the poor townscape quality of the Homebase site. So your views as to whether it should be its importance as a non-designated heritage asset?
There are two things, two sort of competing things, if you like, madam. So the first thing is the sort of intrinsic interest of the technical design of this building as a sort of Grimshaw structure, and it's got that sort of spine that runs along it, and you've got the mast, and it's got the sort of the roofs hanging off the spine, if you like, and so that gives it sort of technical architectural interest, if you like. So that's where the significance of this building derives from. There's then, so the point that I make in section 5 of my proof is there I talk about, and you'll see that what I say is the poor townscape, and so there's a difference between its architectural interest and the way in which it relates to the townscape. So in townscape terms, you've got a low-rise sort of industrial shed, if you like, almost a very interesting industrial shed, but nevertheless a sort of low-rise industrial shed surrounded by an apron of car parking. And in that sense, I think its townscape contribution is bad. It sort of, in that sense, it detracts from the townscape because it doesn't have that enclosure that you would associate with the Great West Road. So that's why I say that. So that's these two things are sort of slightly, I suppose, in a way, there's a tension between the two, but they're different things.
Okay, thank you. That was it from me. Just other than to confirm that people have talked about the Scion Vista, the Scion Lawn, the Scion Lawn and the Scion Outlook. They're all one and the same part.
Scion,
at the end of the.
That's it. That's how I understand it,
Yes.
madam. So Scion Lawn, I think I use Scion Lawn, and I think others use Scion Outlook. But I think for
They're
me,
all one
that
and the same.
encapsulates that sort of open area
It's that
there.
lawned area at the end
The
of
Vista is the
Vista.
linear
Yeah.
thing that doesn't actually align with Scion House.
And that's what I was going along. I thought I'll just take the opportunity to just double check.
Thank
Okay,
you.
so, Madam, to just be clear, then the Scion Vista is not the same.
No, it's the
Scion Vista is the long avenue,
yes,
and it's the Outlook and the lawn that are
yeah,
interchangeable.
those are Okay, that's it from me. Thank you. Anything in re-examination?
Madam, thank you. 2 points I need to pick up, two only, both relating to methodology. The first of those points, Mr. Froneman, relates to questions put to you early on regarding the Tulip decision and the Citron decision, those being core documents 9.1 and 9.8. We don't need to turn them up. But Learned Friend took you to those decisions and reminded you what was said there, and the point really that as regards determining the degree of harm, the key point is not whether some significance is left untouched, but rather the importance of what is affected. Do you recall that? I'm paraphrasing slightly, but that's the...
I do recall that. That's actually what I wrote down as well.
Yeah. And you agreed with that approach, subject to your points on contextualization and calibration, if you'll recall.
Yes, that's it. I also, it might not be in that particular answer, but I also mentioned the qualitative consideration. So in other words, it may just be a small component, but an important one that's being affected. And so therefore that, it's not just a sort of numbers game, if you like, or sort of a proportion game, but also the importance of what it is that's being affected.
Yes, thank you. I've got two short questions on this. First, the reference in the Tulip decision and the Citron decision is to a key point. That is to say, the key point is not whether ... It's said that that is a key point. Is it said that that is the only point that is relevant in those decisions?
No, it just is a key element, and in both those cases, the key element, the thing that was key was the setting, and that was, of course, not one part of the setting, but the setting on the whole.
Yeah. Can we turn also, please, to the Citron decision, and can we go back to paragraph 1515, which is the point paragraph that you were taken to? So that's core document 9.1. It's page 127 in the PDF.
Yes, I have that.
I'll just wait while the inspector manages to turn that up. (127), madam. And we see there in the second sentence the text that I put to you a moment ago. However, the key point is how important the aspect that would be affected, that is the setting, is to its significance. And that was your point about qualitative. Running down to the end of that paragraph, final two sentences, either way, harm to the setting of the orangery would also harm the OUV of the WHS. The weight to this should not be reduced just because it only affects one part of a large World Heritage Site. So the reference there is reducing weight. Mr. Froneman, have you at any stage ever said that weight should be reduced? That is to say, the weight attaching to such harm as you identify should be reduced because it only affects one part of the heritage significance of the World Heritage Site? Or has your assessment been as regard the degree of harm being caused?
No, that's no part of my evidence. And the only other thing that I would draw the inspector's attention to is that phrase that is used there by the inspector, in any event, it is the orangery, or either way, harm to the setting of the orangery. And madam, I don't need to remind you that the orangery is itself grade 1 listed. And so even if the World Heritage Site wasn't affected, there would still be harm to the significance of the orangery, which I think is why the inspector drew in specifically the orangery there.
The second matter I want to take you to, Mr. Stroud, is this. There was quite a lengthy exchange between yourself and Learned Friend relating to cumulative impact. Do you recall that?
I do recall that.
And he was putting various propositions to you, and you were providing your assessment as to how guidance as regards cumulative impact should be applied. In the context of some of your answers, both early on and indeed later on in your cross-examination, you referenced the approach that had been adopted by Mlynn Friend's own witness, Mr. Stroud. And I'd like to look at that in the context of Osterley, which is the assets that Mlynn Friend spent some time talking to you about. Can we turn, please, to Mr. Stroud's paragraph 6.140?
Which page is that on?
That is
Sorry.
page 169 of the internal page numbering of Mr. Stroud's proof.
6140, yes,
Yeah.
I have that.
We see above that paragraph the subheading assessment of harm.
Mhm.
And I suppose for completeness, we should note, or the inspector can note, that this is a section which deals with Osterley House and Park. It begins on page 153 of Mr. Stroud's document. It contains a number of subsections. The first one is assessment of significance. Then we have architectural design and interest, other categories of interest, other listed buildings, contribution of setting to significance, and on and on. Then Osterley Park Conservation Area. And then finally, we come to assessment of harm. That's at 6.140.
Mm-hmm.
Reading that paragraph, the first sentence is this: Osterley Park's setting is already affected by nearby suburban development and views to more distant large-scale developments. Now we have, despite this, ... 6 lines down, sentence, the proposed development encroachment from close proximity into more views, introducing a new urbanizing effect in views over the southeast boundary, would be a marked addition to harm to the setting of the park. This, and in particular the effect on White Green Gate, would cause a medium-low level of less than substantial harm. This adds distinctively by its greater proximity to the existing harm caused by more distant and large tall buildings. Now, looking at that paragraph, I want to understand this. Has Mr. Stroud considered the harm that would be caused by the proposed development in addition to, that is, over and above existing harm, or has he approached his assessment of harm by aggregating the effect of the proposed development with the existing buildings so that all the harm is bundled up together?
He didn't do that. He didn't do that at Osterley, and he didn't do that anywhere else that I could tell.
No.
And he doesn't really engage with cumulative. I didn't see any assessment of. I didn't see any headings of cumulative harm in his assessment. And what I also don't see is anywhere where he explains how it is that he approaches cumulative harm and where it is that he returns the clock back to when he does that.
In circumstances, well, we know what approach Mlynn Friend was urging on you in cross-examination. What do you say as to whether Mr. Stroud has himself adopted the approach for which Mlynn Friend is contending?
Well, I don't see Mr. Stroud having adopted this approach at all. And so it seems, for the record, I don't see Dr. Mealy having adopted that approach either. So what we have is 3 witnesses at this inquiry. None of the witnesses have adopted this eccentric approach that Mr. Linner's put to me was what I should have done, it seems.
Just on that point, I mean, you've referenced Dr. Mealy's approach. Was Dr. Mealy criticised for the approach which he has adopted as regards this particular methodological issue?
No, I don't recall any such criticisms, and I don't recall Dr. Mealy being asked about how he totted up the cumulative harm in relation to those heritage assets where he was extensively cross-examined, for example, Kew and Sion. I don't remember any of this sort of line of questioning. So, yeah, I didn't see that.
Thank you very much, Mr. Friendman. I've got nothing further. Thank you, madam.
Thank you very much indeed. Thank you, Mr. Froneman. So if we adjourn for lunch now, say till 1:15, and then we'll resume this afternoon for a discussion about the planning obligations and the planning conditions that have been circulated.
Yes. May I make a couple of points, ma'am, before we do
yes.
break? Firstly, just to draw your attention and others to the fact that the note on the visualization tracking and the position of viewpoints and so on has been submitted through the programme officer to you.
Okay.
You won't have seen it yet, ma'am, but it'll be there, and it will be sent out, no doubt. If anybody else wants a copy in the interim, obviously we can. It's been circulated, I'm told. Anyway,
Okay.
Thank you very much. That was the first point. Second point, ma'am, was just for the sake of form, really. Forgive me just for taking 30 seconds on this. Very kindly, Mr. Booth made the point that I was going to make about my witness, Dr. Mealy. No criticism here of Mr. Linus not having been cross-examined on that cumulative methodological point. No criticism of anybody, but just to put a marker down, ma'am, that since it's in play, if you like, I will make submissions about that point.
All right.
Nonetheless. Okay. Thank you very much.
Thank you. If we adjourn then until 1:15. Thank you. a look at that note yet. I'll do that this evening.
Thank you, ma'am.
Anything else? No. Okay, so if we start with conditions then, Homebase. I did send round some further comments on the latest iteration. I think, well, Mr. Warren, you asked for a rough guesstimate of timing. We went in the region of 2 hours. I'm hoping it's going to be less than that. So, has everybody who wants to take part in this got a copy of the conditions before them? So I don't need to read out the conditions each time, yeah? Yep. So condition 1, time limit, no problem. Condition 2, the extent of development and the approved plans, that's conditions 2 and 3, no problems. Condition 4, the logistics and environmental management plan. Where did I get to with that one? On the 1, 2, 3, 4th. Oh no, 1, 2. I don't know how you want me to count the bullets. 1, 2, 3, 4, 5. 6th bullet up from the bottom. A review mechanism of the approved noise and vibration suppression measures. I had a quick look as best I could at the British Standard, but I couldn't see where in the document it sets out what's to be provided. So it says a review mechanism of the approved as defined in the British Standard. So where is the review mechanism? Is it the review mechanism that's defined in the British Standard? The noise and vibration suppression measures defined in the Standard? I couldn't find either in the Standard.
Not sure we know. Ma'am, we'll have to look. I'm sorry. That's the honest answer. I don't think we know. It's intended, I think, to be the review mechanism, which is referred to or defined in the document, I think. But we'll have a look.
I couldn't see details of what a review mechanism might comprise in the British Standard. So we'll come back to that one, yeah? Condition 8. So 5, 6, and 7 were okay. Condition 8, Japanese knotweed. My question there is, does that meet the test of necessity? My understanding is that the legislation for knotweed deals with it as a controlled waste, so that if there is any transgression, it's covered by the legislation.
I think, Madam, I think that neither of us two parties are experts in other legislation, so we think it's we think it's necessary, meets the tests. I'm not sure how much.
Pardon it, what?
I think we're not experts in any other legislation that might capture this, so I think we both agree that it is necessary. I'm not sure how much expertise on Japanese knotweed there's going to be across the tables here, but we are in agreement on it.
Well, my understanding is that as a controlled waste, if it's not disposed of correctly, that can lead to prosecution. That's under the Environmental Protection Act. Any cut material and soil that contains the rhizomes has to be disposed of as controlled waste, so that's covered by waste regulations. You're not required, the regulations don't require it to be removed, but you can be prosecuted for causing or allowing it to spread into the wild. It's the Wildlife and Countryside Act.
I think it'd be difficult for me to add any more on this one, Madam. I think I defer to your expertise on the other legislation. I'm not.
I'm not professing any expertise.
I think, for the sake of completeness, from the council's perspective, we'd prefer to keep it, even if there is other legislation that will assist as well.
Okay, got a note of that. Thank you. Condition 9. I've got C condition 40. Okay. Is there some overlap there? So one requires a circular economy statement. The other one needs okay, the other one's checking that what's in that statement has materialized. Okay. So in condition 40, there's reference there to the recycling and waste reporting form. And the notes that somebody added in the track changes said that it was it's part of condition 9, but condition 9 doesn't actually require a recycling and waste reporting form. But the construction condition 4 does require a demolition and construction waste management plan. So is that already covered? Does it need including in the condition 40?
I understand the recycling and waste reporting form would form part of the CES that's submitted under the.
So it doesn't need mentioning in 40 as a separate thing. It's part and parcel of the CES.
It's part of the CES.
So we can take that out of 40 then. And then it ties in back to 9. Okay. Condition 10. It just says a final detailed drainage design. I think that should be a reference to surface water drainage. Yeah. All the 3 bullets all relate to, sustainable drainage schemes, management of them, that kind of thing.
Yes, I think that's right, madam.
Yeah. Uh, 11, 12, 13. Condition 13, third bullet, refers to synthetic surfaces for ground and roof terrace level. Is there any synthetic? There's no ground surface on the Homebase site, is there, that would be the subject of a synthetic surface? Isn't it just the roof terrace level?
I think that's right, Mr. Roberts. Is that correct?
That's my understanding of the details would obviously be subject to that condition.
So it's just for the roof terrace level. 14, cycling. 15, cycle parking. 16. 17. So the BREEAM certification requirement refers only to the food store there. Does it need to refer to the other commercial units? I think on the Tesco's one it does refer to the other, the commercial units on the Tesco's scheme.
It's to do with the size, and the policy requirement refers to the submission of BREEAM over a certain size, which I can't remember exactly. I think it might be 500 square meters.
So I think we discussed, that's coming back to me now. So the Tesco's triggers it, the other ones don't. Thank you. $18. So 18, we've confirmed, relates to future management, yeah, and monitoring. Okay. 19, birds. 20, parts B and C, do they need moving to a separate condition under preoccupation conditions? Yeah. Okay.
I'm not sure, madam. They deal with occupation. I think that the development should not be occupied. Yeah, I think both B and C are preoccupation,
Yeah.
so I don't think so.
So they do need moving to preoccupation.
Preoccupation. Yeah, sorry.
Yes.
Yeah, sorry. I misheard you there. Sorry.
Wind mitigation. Now I haven't had chance to check this. The accessible dwellings one at 22. It crops up in the Tesco's one, where it's covered by the planning obligation. I haven't had a chance to just double check the planning obligation for the home base. Is that caught in any event? I think someone ought to do a
Unless
word
Mr.
search on
Roberts
it.
knows off the top of his head, I think we'll have to cross-reference and check also, madam.
My understanding is the reference within the section 106 is to the accessible dwelling requirements for the affordable housing.
Okay. Can you just take me to the part of the planning obligation where so it's under the affordable housing bits? Because I saw it was in the Tesco's one, I saw it was in there, but to me, it wasn't clear that well, other than that it's in the affordable housing. Is it sufficient that just because it's in the affordable housing section that it only relates then to the affordable dwellings?
That's certainly how the 106 would work, ma'am.
Yeah.
Absolutely. So there's an overlap because this talks about all of them, I think, but there's part of that which is still necessary.
So
to be
there's
in
some
the-
duplication in the suggested condition.
there's a
So the
little bit of
condition just should relate to the ones that aren't
market,
to the market
market
units.
units. Yeah, I think that's right.
Yeah.
I think it could, madam. I mean, the 106 is only dealing with affordable housing as a planning obligation, and so the council wants to make sure that the right amount of the affordable units are accessible. But then there's an overarching requirement for 10% of the units as a whole. So there's intrinsically overlap there, but I don't think there's a necessity to overcomplicate the planning condition. I think they work alongside one another okay.
Right. Well, I mean, the section 106 is pretty specific about the number of wheelchair units for the affordable housing offer.
Yeah, I think that's right, and I don't think there'll be anything wrong with the planning condition solely dealing with the market units, but similarly, I don't think there's any conflict between the two.
Okay.
I think they can sit side by side.
Happy to leave as is then? Okay. Photovoltaics, 23, okay. 24, sound insulation. So my first question here is, what justifies a requirement for higher than the building regulations?
I think we'd have to refer back to the policy, madam, to see whether that sets out the requirements. If you'll leave that one with me, I can have a look.
Okay, and then there's the added bit that says details shall include a scheme to test the sound insulation, but it doesn't say test it by when. What comprises that testing, but who's supposed to carry that out? I mean, as it's written, it doesn't mean very much. It just says it'll test it.
Should the scheme include details of who and when by for approval?
So do you want to come back with some revised wording?
Yeah, thank you, madam.
Do you understand why I think it's not
Uh,
clearly worded as it is?
yes, I do.
Yeah.
Yeah.
Okay. So we haven't got a 25. So 26 is the building emissions. I think it requires, needs to be, shall be submitted to and approved in writing by the local planning authority.
Yeah, I think that's right, madam. Yeah, that's just
That's
yeah, that's
missing
a
from
drafting
that, yeah.
point. Yeah, absolutely.
'27. 28, okay, 29. 30 was the electric vehicle charging points. 31. 32. Okay, 32. The diffusion tube monitoring. Yeah, how long before occupation should the monitoring take place was my question for this, because you just got prior to occupation of the units, the dwellings, the monitoring is to be undertaken. So is it? Oh, that's the methodology.
I wonder if that's a similar point, madam, insofar as what comprises the methodology should be specified.
Yeah.
So I can tidy that up as well.
Methodology, it's the methodology and it's the timing of it as well, and how long.
Which could
Because it says if at any time during the monitoring the measurements go above a level, that triggers an action. But if you're only measuring it for one day.
Yeah, understood. So the what comprises that methodology should be clarified in the condition.
Okay, so you'll come back to me with wording for that as well, will you?
Yes.
Thank you. 33. Okay. Oh, 33, Part D. It was somebody, maybe I changed it, but it needs going back in now because we've added Part C. So Part D should refer to Parts B and C.
Yeah, that's correct, madam.
'34 and 35. Are they covered by the planning obligation that require the submission of a car park management scheme? Section 5, commercial car park management plan. I don't know if there's a. There's a residential car park management plan and a commercial car
There
park
is.
management plan
Yeah.
required by the planning obligation.
Yes. I don't think, looking at it, that there's anything different intended to be captured by the two. It's in the 106, you're right.
Yeah.
So,
I think that sounds right, madam.
Okay, so the conditions I know the conditions are usually to be preferred if it's in the planning obligation. I thought it was slightly more, it covered slightly more the planning obligation, which is.
it's there's been quite a lot of discussion about
Yeah.
this point,
So we
and
delete
it's wound up in
34
the
and
106.
35.
Yes, I think that's right.
'36, that's okay. 37. Okay, 37. It's still worded as prior to first occupation. This is the water infrastructure. But doesn't it need to be pre-development? Wouldn't the water infrastructure works be underground?
I can see why you're asking the question, madam. I guess the reason that the trigger is as it is. A is because that's what Thames Water have asked for, but B, I guess the need for water would not be there before occupation. But I understand why you asked the question.
Well, it's the development, it's the phasing plan that's to be submitted. Oh, maybe that's not. So it doesn't require details of the water infrastructure. It just requires details of a phasing plan.
Yes, that's more to do, ma'am, I'm told, with looking forward a number of years as to when units will be coming. No pun
Okay,
intended,
so it doesn't, it's,
So it doesn't need to be done before
That's why it
unit
does-
number 1 is occupied. It's prospective, so that
Yep,
Thames
I'm
Water
happy
can make sure the capacity is there.
Yep. So the post-occupancy conditions, the heading needs moving above secured by design. So the secured by design is post-oc, oh no. No dwelling, no, it's pre, that's right. It's all right where it is. Ignore what I just said. 38's okay, 39. '40, we've deleted the reference to the wastes, recycling and waste reporting. 41, noise. That was okay, it was 42. The bit about the bedroom noise levels, are we taking out any reference to LA max noise levels now, just relying on the LAEQ?
No, we were looking to introduce the word typically, because the question you raised was obviously a fair one. Mr. Roberts, in his note on the track changes, has made reference to WHO guidance and the PPG. So we remain of the view that it's appropriate to leave in the max.
Well, there's a
but
comment
quite-
there saying we're happy to delete the sentence relating to LA max, as the previous sentence relating to average noise provides adequate control on a suitable internal noise environment.
Yeah, that's our comment as a suggested alternative to introducing the typically, so it doesn't just relate to one-off exceedance of the maximum noise level. We see the issues with that, and so we suggested the alternative of just deleting and leaving with the LAEQ.
I mean, I struggle slightly with the LA max. Well, particularly the 15 times that, because you can't. That's outside. That's out with anybody's control. The number of times. What's important is the protection that's put in place for the any future residents. So, are you saying we just finish after it should not typically exceed 45 dB then? Then how do you define typically?
Well, our suggestion was to take out that whole sentence on LA
Well,
max.
that's what I thought, and
Yep.
then you said not.
Okay, I think me and Mr. Roberts had crossed wires slightly. I mean, frankly, madam, I understand where you raise the point. It's
The condition has to be enforceable.
I agree with that. I'm not going to put up a fuss if that bullet point if that requirement is removed. I can understand why you raise it.
But if there were LA max noise levels a lot, that would affect the LAEQ, wouldn't it? So it's caught by that in any event.
I think that's right, madam.
That's the extent of my knowledge on noise. '43. That was sorted. 44, does that need to refer to weekends who, it doesn't, it just says between 7 in the morning to 10 at night, the commercial floor space. Is that every day?
The difference in there is because of the size of the food store being caught by the Sunday trading hours.
So that everybody's content that the other commercial floor space could be open 7 till 10 every day.
Yes, madam, it's a small area of space.
Okay. 45. And removal of permitted development rights, use class E, part G. I think there were different views and different thoughts coming on that, but I've no idea. I can't remember now off the top of my head what they were.
Do we have different views and thoughts, Mr. Roberts? I'm not sure we do. Yeah.
Well, someone took issue with
I'm
it.
not sure we do. No.
I think we're happy with it, madam, collectively.
Okay. 46, landscape. Okay. Other questions I had, there's condition 20 on the Tesco is external lighting condition. Do you need an external control over external lighting here? Thinking on the roof terrace level.
I would have thought we do. Do you agree, Mr. Roberts?
It's not been raised before, I think perhaps due to the nature of the scheme and the public spaces there are within the Tesco scheme. That was the only difference that I recognised.
So is a condition on external lighting necessary for the podium, well, roof terrace podium level? Because there's external space there, isn't there?
But that's within the development itself, as opposed to lights spilling out into the public domain.
Doesn't the open space go to the front between the blocks?
Yes, I think there is exposed spaces. I think that's probably a wise suggestion, madam. I think that would be required.
I'm just asking for views. I'm not suggesting.
Yeah, we're not opposed to it if it's considered necessary.
Thames Water suggested that interceptors were needed in the car park. I think that was when they restated their comments in response to the reconsultation on the missing figures and things. Well, my question is, why was that? So Thames Water recommends that petrol oil interceptors be fitted in all car parking areas. Is that necessary, or they don't? They just say recommend that they be fitted. It doesn't suggest a condition to that effect.
But it's not something that's been raised previously, madam, and no, we don't suggest that a condition is required.
Okay. Piling of the conditions. Okay. Network Rail suggested. So my question is, in light of the Network Rail comments, they want to be notified prior to the commencement of works, so that they can make an assessment, I think, in terms of safety of. Due to the close proximity of the development to Network Rail's land and the operational railway, the request that the applicant or the developer engages with the asset protection and optimisation team prior to works commencing to allow them to review details of the proposal to ensure can be completed without any risk to the operational railway. So my question is, do you need a condition that requires that developer to notify not British Rail, Network Rail of the commencement of works or not?
I think that sounds like perfectly sound advice from Network Rail, but it doesn't seem to me necessary in the form of a condition.
Nope, that's fine. Okay. And then we've got the conditions suggested or continuing to be suggested by the residents, and I can't find them. everything together, all very organised. Bear with me. I've just seen them. Here we go. Oops. So one of them is the a continued suggestion about a trolley management plan. Just, Mr. Roberts, can you give us a bit more information about why you think that's not likely to be a problem? Sorry, why trolley management, isn't likely to be a problem.
I think we'd submit written comments on this before, and it's as per our comments, the nature of the retail store and the car park and it being enclosed within a building is the primary reason.
Strack?
We've noticed an increasing discarded trolley problem in the area. I think when the store was built 27 years ago, I don't think we had a problem until a few years ago. And I think that's happened as a result of more CPZs being introduced, more tenants moving into the area, fewer people having cars. I mean, you can tell by just, the bus, the H91, which only operated at certain times, was single decker and is now double decker. So you've got far more people using public transport, not having cars. And as a result of that, people are walking to the store. And when they've got heavy shopping, they're actually taking the trolley outside of the perimeter of Tesco. And we're reporting Tesco trolleys on a daily basis. And I think you can check that by presumably contacting Trolleywise to see how many trolleys are reported on a daily or a weekly basis. And they're also reported via Fix My Street to Hounslow Highways, who I understand don't have an arrangement with Tesco, and I think they're just dumped by Hounslow Highway somewhere. So there is a problem. And in the new store, you might have the car park upstairs, but it's not the people who are driving who are leaving the trolleys. It's people who are pedestrians who are going to the store from a slightly further distance. And if you think about where the store will be at Gillette Corner, and you're going to have the huge development on the Tesco site, and I can never remember which way around it is. I think on the Tesco site, it's 1 in 5, or is it 1 in 4 that will have a parking space? A lot of people will be going to the new Tesco store from the old Tesco site, and it's actually a 5-minute walk. It'll be a 5-minute walk. If you're carrying heavy bags, you'll be tempted to take the trolley. Now, we've been talking to Tesco. We don't have much contact with Tesco at the moment. I mean, we are trying to, and asking them to introduce a trolley management system now in the current store. We know that in Tesco in Twickenham, at the Tesco Extra store there, that you have to put, you have to pay to use the trolleys. I think you have to put a £1 coin in. Tesco Osley are telling us that there's no such system, which seems odd. But anyway, there is a problem, and it will continue to be a problem. And I haven't heard any arguments to the contrary. We live there on a daily basis. We see the problem. Can we please have a trolley management system?
I think just to add to the point that I made before, I think the nature of it being within a building does change and does make it easier. We see this as a internal management issue for the retail store rather than something that affects the environment beyond. With a building, you can have devices that stop the trolleys from rolling outside, and they would have security and people within the building that would.
Isn't that a trolley management system?
Well, it's the retailer managing the environment themselves. We just we question the need and the evidence that there is for a specific condition on it for the council to monitor.
Sorry, Ma'am, can I come in on that? Yes, I think anything that would stop the trolleys leaving the perimeter of the store would help. But I agree, that's a trolley management system, and we would like to see a condition put in there.
Okay. So happy to leave that to me then.
I think so, ma'am. I think
Yeah.
just in terms of the tests, it's a necessity point. I think if that's the Tesco way forward enclosed, and yes, you're right, they would manage it, is a condition necessary.
Well, some of the well, a number of the other conditions, it's loose on the meeting the test of necessity. One of the other conditions pursued by the residents is improvements to Scion Lane Station. Mr. Roberts, do you want to say something about that?
This, I think, was one that we did discuss in the roundtable dealing with local infrastructure and the fact that Network Rail and Southwest Trains were consulted on any need that they saw, and none was identified.
Could I come back on that one?
Yeah, but let me just make the point as well. The condition, the wording that you're suggesting requires work to be undertaken off-site, and you can't secure that. You can't do that by condition requiring that something happens to somewhere else.
This is where I get confused between S106 obligations and conditions. And sorry, if I can make a point, in the documents that have been submitted, are these are conditions? Yes. Can we have a heading on the documents that these are that it's a condition document rather than an S106? Sorry, we get terribly confused with all of this.
Right, this is your note. I asked for
Yes.
a composite note from yourselves
Right,
to
yes.
make sure that I
Yes,
would
yes, no,
cover
yeah.
all your
Yeah.
concerns.
Yeah, no, I'm saying in the papers that we've received today.
Oh, I haven't.
So,
I don't know what
so
papers
this is
you've received
we're
today.
talking about conditions today, but can we ask for something in the S106 agreement for lighting at the station? Could that be included there?
That would be by a financial contribution secured towards those works, but that's not being proposed. Financial contributions have to meet similar tests to planning conditions, one of which is a test of necessity.
And I understand that the SWR said that no improvements are necessary, but again, we use the station, we know what it's like, and with, at times when there are only 2 trains an hour and it's dark, it just doesn't feel safe, and crime is increasing in the area, and lighting would be additional lighting at the when you're sitting there at the station at night would be very helpful and make people feel more safe. And be encouraged to use the station at night, or use the trains at night.
Okay. And then similarly, the other condition about the subway, Mr. Roberts.
So the improvements to the subway are covered under the Section 106, and I think they're headed Public Realm Works, and there's a plan appended to the Homebase Section 106 that shows it indicatively. But the improvements to the subway would be delivered as part of the Section 106. There's no need for a separate condition.
I think the point that the residents are making is that they don't think that the suggested improvements there are sufficient.
Sorry, if I can add, I think
Yep.
we felt that the amount, I can't remember what the amount of money was. Is it 20,000, 120,000?
135,000.
I don't think it's that, and I think it was it talked about surface improvements, but the actual subway, as you go through it, people don't feel very safe using it. So it's what can be done to improve that, and I think that would cost considerably more than the 120,000 that's allocated at the moment or proposed at the moment.
Are you bringing any evidence for that? No.
Sorry, we're lay people, lay residents.
Ma'am, it does just this is page 7 for your note, ma'am, page 17 in the definitions in the 106. So public groundworks, 135,000 odd pounds, and it says at the end, and which for the avoidance of doubt shall include environmental improvements to the existing underpass as identified. So that point is in the 106. It's not
So
just surface.
what does the corresponding annex say? The plan for those works.
Plan 6 it is, ma'am.
Yeah, there is an annotation on the plan which talks about the type of thing, and it does mention lighting for the subway and also material improvements as well.
Okay, so that's on the plan, and that's secured by the planning obligation. That includes lighting.
It does. It's at Appendix 7, ma'am, of the
Okay.
document.
Let's see what it looks like if this goes ahead. But I think we will continue to have concerns because we just don't think it's going to be addressed adequately.
Okay. Supply management. Okay. I think that covered everything in relation to Homebase. Anybody else got anything to say on Homebase? Nope. Tesco then, still on conditions. One, 2 and 3, all okay. 4. Same point about the British Standard. You'll come back to me, yeah? Five. Sorry, no, I'm on the wrong. I'm still on the Tesco's one, sorry. Okay, 1, reserved, start again. 1, the reserved matters. So you've got access in there. Access is a matter for condition now. It's not, it can't be a reserved matter. So it's access is for determination now. Appreciate it's only one element of the access. But I've had a look at the development management procedure order. The access can't remain as a reserved matter there. It needs to be as a separate condition, the other access.
Yeah, I think that makes sense, madam. Thank you. Thanks for spotting that.
Okay. 2 and 3 were okay. Phasing 4. The section 106 refers specifically to 4 phases. So does this need to be to say not more than 4 phases? I don't know.
I'm just going to remind myself what context the section 106 phases are referring to.
In the definitions, you've got phase 1, phase 2, phase 3, phase 4. Affordable housing units, accommodation schedules for the different phases. Does it matter?
No, I don't think it does. If the legal agreement phasing is related to the affordable housing, that's a different thing to what this condition is looking to do.
Okay. 5. Okay. Started off querying all the plans, but then when I did eventually find them, they're all parameter plans, so it is appropriate to include them on the list of plans there. Does the site location plan need listing?
No, we say no.
I don't know. It's just if it was a detailed application, it's shown on other plans, and I wouldn't normally put it on a detailed application. But for this, does it need the red line plan including?
Is there a reason why it shouldn't be?
No?
No, I don't think there's a disagreement.
Okay.
Yeah, let's add it in. Thank you, Madam.
And then I made the comment before, the original list suggested including reference to the development specifications plan revision 2, but I wasn't clear what that showed. Is it actually a plan? Is it a document that needs complying with, and if so, does it need to be in a separate condition?
Yeah, so
Is it covered by other things?
it is a separate document, and it's a document that includes well, the floor space restrictions are now in condition 6, I think, but it does include other details, some of which are duplicated in the design code. But what the authority and we have discussed is that rather there is a condition relating to the design code which requires a statement to be submitted at the time of the reserved matters demonstrating compliance with the design code, and it would make sense for the same to be extended to the development specifications document as well. So it allowed the authority to check when assessing reserved matters that it was compliant and consistent
Okay,
with
so
what
when
had
we
been
come
said.
to that condition, will you remind me and we'll look at wording
It's
then?
condition 7, Madam, so we're nearly
Okay,
there.
so we'll be
but-
there shortly. 6 was the quantum of development, so that's that. Yeah. So 7 then.
Yes, what we're suggesting, Madam, as Mr. Roberts has just described, is following on from prepared by JTP. It should read and development specifications revision 2 prepared by WSP, but we'll provide that drafting on the version that we send you next.
Okay. Thank you. 8. So 8A requires a design statement, but doesn't 7 require a design statement in any event?
Yes, that's duplication now.
Agreed.
And then what's on there is O, the whole life carbon assessment. Is that covered by condition 19? Which requires a whole life carbon assessment for each phase.
I think you're right, ma'am. I think it's just a question of the details that are spelt out in 19 that
So
aren't.
I'll delete the reference. I'll delete O because there's more detail in 19.
Yes, yes. I mean, 19 I think covers the same
Yeah.
point, phase by phase, and with a lot more detail. So if one has to go, it should be O, I think, rather than 19.
Then P, should that relate to surface water, given that it's to do with flood risk and things?
Yes, I think so,
Yep.
Madam. Yep.
Then we've got T. I think that's unnecessary because you've got appearance is a reserved matter. So reserved matters, the external appearance will include materials, and landscaping is a reserved matter. So you've got the landscaping there as well. Yeah.
Probably fine. I think the landscaping definitely fine. I guess there is a hypothetical scenario where the appearance of a building could be shown without specific reference to its materials.
Well, it's external. It's its appearance, which would include materials.
It should do, certainly. Yeah, it should do. Yeah,
Okay.
fine, Madam.
Sorry, just going back to R, the ecological enhancement and mitigation measures. It says biodiversity but net gain calculations. Does it actually need to refer to a specific minimum 10% biodiversity net gain? you've got a greening factor of 0.4. Presumably that means something, but it just says biodiversity net gain calculations. There's no requirement for there to be.
Yeah, I'd be interested in Mr. Roberts' view on that.
At this stage, in terms of the determination of this application, that 10% requirement isn't a policy requirement now, is it?
No. Yeah, I think that's probably the right point. So we've got the 0.4 urban greening factor is a London plan policy, but there is no specific policy requirement for a set BNG. Yes, I think that's correct.
So the amount would be for the council to consider, should it everything get to that stage, that would be for the council to consider whether the appropriate biodiversity net gain was achieved or not.
I think that's right.
Consider
So
that in
we've
the
got
light of whatever was relevant at the time.
That's right. So we've got the NPPF policy requirement for a net gain, but no requirement for a specific figure.
Okay. 9. Okay, 10. So condition 10, I would say third bullet up. Oh no, third, 4, 5, 6, 7, 9th bullet up from the bottom. Review mechanism. That was about to do with the British standards. It's the same point. So you'll come back to me on that. Yeah? Yes. And then 1, 2, 3, 4, 5, 6 down from that. All deliveries to take place. So it's all deliveries to the site, Monday to Saturday. Should it include, and at no time on Sundays or bank and public holidays? I think that's what it does in the Homebase.
Yeah, for preciseness,
Yeah.
that sounds wise. Thank you.
Um, 11, okay. 12, okay. Oh, then the numbering goes wonky. So go 9, 10, 11, 12, then back to 9. So that's fine. 10. So this is surface water drainage. Oh yes, somebody's added a bit in here about bird hazards. You've got a separate bird hazard condition. This condition's to do with flood risk. Yeah.
Isn't the reference there to that advice note, which is about bird hazards from drainage schemes?
Yeah, but the bird hazards there's a separate condition dealing with bird hazards. Bird hazard management plan. So that's to do with the flat, shallow, pitched or green roofs. But could you add in there water bodies as well to the bird hazard one? Yeah.
Agreed.
I think you could do, madam. Yeah, it seems to me that it doesn't matter where it lives, and there's justification for both. So yeah, we're happy with either.
And you don't need the bit where it says prior to first occupation of the development in that phase, because one of the requirements of the condition was the submission of a doesn't say, should include, if it includes a timetable, that, yeah. Okay, makes sense to me. Yes, includes a timetable for implementation in the bullets below. You've got a timetable secured for implementation. So saying prior to first occupation, that's unnecessary.
Where's the reference, sorry, madam, to the first occupation?
It's says development in the relevant phase should be carried out in accordance with the approved details prior to first occupation of the development in that phase. The details to be submitted shall, and then you've got 3 bullets.
Yeah, agreed.
Yep.
Thank you, Madam.
Okay. Drainage design. I've got a question. Is this to do with foul water? We've already got surface water on that previous condition 10. So is this to do with foul water? It wasn't clear because you've then got the same 3 bullets which all relate to sustainable drainage schemes. So is this a duplication? You've got wastewater later on.
My understanding, Madam, is that this is the final detailed scheme prior to it kicking off and being used. But I'm just working through it, so you might have to bear with me.
Maybe it's 10 that needs deleting and 11 keeping.
I'm struggling to see the difference between them, really, apart from some minor drafting points. So, unless there's any advice from Mr. Roberts, I can't see the difference.
No, agreed. It looks like a duplication to us.
So which one goes?
I can see that condition 11 seems to make reference to detailed calculations. It seems a bit more detailed, condition 11. So perhaps on that basis, condition 10 should go.
Okay. Um, 12. Again, I didn't understand why you think this isn't covered by other legislation. So all birds, their nests and eggs are protected by other legislation. It's an offence to intentionally kill, injure or take any wild bird, destroy nests while being in use or being built.
I think it's a similar point from me, Mum. I think if that's right, brilliant. We're not sure on that. Obviously, we hear what you say, and so would prefer that it was protected by condition also. But if there is other legislation that does the same job, then fine.
Okay. 13, just adding water bodies there to the roofs. Yeah, for the bird hazard. 14, water use. 15, BREEAM. 16. Okay. So you're coming back to me on the similar condition on the home base. Is it about the building regs? My question was, how is it justified?
Yeah, we'll have a look into that. That's a policy point, so we'll look at both
Yeah.
at the same time. Thanks.
Um, 17. My question there was necessity because it was deleted from the home base application. So on the home base, you've got that the sound insulation condition, and that's it.
And so what we've done is combined it with the condition above. So
Sorry?
What on the home base, the sound insulation testing, the testing details became part of the condition above, as
Right.
submitted at the same time. So the same approach could be taken on this condition.
Okay. 18 was sorted. 19 carbon cycle. So we're keeping that, yeah. Move parts B and C to preoccupation. 20 external lighting. 21 waste management, 22 waste management, yeah, they're okay. 23 covered by the section 106 is my question.
Yeah, I think we would agree as per the car park management plans.
Yeah, Mr. Smith.
I'm just control Fing the legal agreement, but I've got no reason to think that's not right, madam. Yeah, I think
Yep.
that's right. Thank you.
So this one, the air quality monitoring, you've actually got the times in the conditions when it's the monitoring supposed to be done. So that was okay. 25 and 26, do they essentially duplicate each other?
They relate. One relates to water supply, and the other one is to wastewater.
Okay. Thank you. 27 should relate to surface water.
Okay.
But the last sentence there, is that covered by condition 10? You've got condition 10 requires a... No, it's not condition 10. Maybe there's two condition 10s. Yes, two condition. Second condition 10. Well, that's now condition 11 we're looking at, the drainage. So that condition required a management and maintenance plan for the lifetime of development. So you don't need it as part of condition 27.
I think that's right, madam. I think as I'm reading condition 27, it requires management and maintenance in accordance with the maintenance plan rather than the submission of one. But yeah, in the interest
it's covered
of
by the other
tidiness,
condition.
yeah, that's fine.
Okay. 28. Okay. 29. Okay. 30 was the accessible. So we left that in, didn't we, on the home base? Plant noise. Internal noise levels. Again, are we deleting the last sentence of the bit for the bedrooms, the LA max?
I think that's fine, madam.
Secured by design. Permitted development rights. And then, yeah, the district heating network's covered by the energy strategy in the 106, so no need for that. Any other conditions in relation to the Tesco site? I think everybody's nearly asleep now. Planning obligations then.
Just quickly, Madam, if I may, on the conditions, how do you want to move them forward? Because we've made a few notes of things that we're
Yeah,
investigating.
There's only a few notes, but yeah, if you can come back to me
Of course,
tomorrow, hopefully.
no problem.
All right,
Thank you.
thank you. Tesco's. Tenure mix. Wheelchair phases, travel plans. I think we picked up everything I was going to say. Oh, the definition, I'm looking at Tesco without first homes. Just, I'm assuming they're the same, other than the first homes bit. The definitions didn't include site-wide delivery and servicing management plan principles. Why I would say that, I don't know. There must be reference somewhere in the text to the site-wide delivery and servicing management plan principles.
Yes, there's a definition at page 27. My microphone on. Page 27. Is that the one, ma'am? Site-wide car park management principles.
Well, that's not
Schedule.
page 27 of the document I've got here.
Oh, sorry. Are you doing with or without first home? Sorry.
Without.
Oh, that's why. I think it should be the same, shouldn't it? In the other one, let me just check. Different page number. Page 23. Sorry.
So it does include them, that's fine.
It does.
Don't know why I couldn't find them. I think my other main query with it was the parking management and the CPZ.
Yeah.
You can't, by planning obligation, stop people applying for a permit. What you can, but in the back of my mind, I've got something about the London. There's some London Act for Greater London Act.
Correct.
But I've been trying to find reference to it and how that relates to the parking. I can't find it. So if that wasn't in play, it's not clear that it's in play. There's no reference to it in the planning obligation.
Right.
So I'm not sure, without doing more investigation, how that applies. But for anywhere else,
you're absolutely right, ma'am. That forgive me, I'm just checking, but I hadn't spotted that. You're absolutely right. It should be there, and it does apply here. So with a London 106 like this, one sees the act referred to in the recitals and then in the relevant bits. So we'll just chase that through.
okay, thank you.
2.1 of the without. Yeah.
Then my other query about.
Sorry, ma'am. Just before you go, sorry, I've just been helpfully told, directed my attention and yours to clause 2.1. 2.1, I think.
Okay, yeah.
CPZ.
So because that's referenced there, that allows for the wording to do with stopping people applying for the permits. Okay.
Yes.
Thank you very much. And then my other query was, you've got the council or whoever has 5 years to spend any monies. Is that long enough for some of the obligations that can't get started until the development's completed and occupied? I mean, when I made the note, I didn't actually make a note of an example of what I was getting at there. And I couldn't find again the bit where it says the council will do it within.
Yes.
It's in there. I just couldn't find it again.
I mean, obviously, ma'am, even though a number are payable on commencement, some aren't. I think some of the trigger points for 106 payments are a little later. So it's a different question in
that would-
relation to some of them.
Okay, so it will be caught.
It will be caught in the sense that even though that some will be spent later than 5 years after commencement, it's 5 years. I'll check the drafting, man, but I think it's
Thank
5
you.
years after they have been paid, right? Obviously, obligation can't bite the council unless they've received the money. So I think that's how
Okay.
it works.
So that was it from me. Can wake up
Anything
again now.
different about the width?
Sorry?
There was nothing about First Homes itself from last time. I wasn't here.
I
if you remember
don't
last
think there
time.
was from last time.
No,
Nothing. I haven't
okay.
looked at it again. I didn't. None of my notes suggested that there were any issues with it.
Thank you, ma'am.
Okay. Anything else on conditions or planning obligations? You all had enough. I love them. Not really. Tomorrow, starting at 9 again, character and appearance roundtable. Just my question is, we don't need to vacate the room till 17:30 tomorrow. Everybody still happy to start at 9, or would you prefer a slightly later start? I'm easy either way.
9, I think.
No?
If would be
Yeah,
very
I don't
happy
know
with
if I
9.
didn't know if people were struggling to get here for 9 or not. I was just trying to be helpful.
No.
I'll stop.
Stop being helpful, ma'am.
Mhm.
No, 9. Thank you very much. No, thanks for
o'clock
asking.
tomorrow
9
morning
o'clock is
then.
fine. Thank you.
And everybody's got sight of the agenda that was circulated. Yeah. Okay. Till tomorrow morning then. Thank you very much.